What is the urgency?
But the gentleman has been terminated from his service since last 6 months, and thereafter notice was issued. Thereafter, matter is not posting for a long time.
When is it? 27?
Deep blocklist.
May I please your lordship? Lordship, I pray for listing of a writ petition and next week of the
Wednesday.
Wednesday of this.
Please, your lordship. Lordship, I beg to mention 2 writ petitions in admission follow.
For
It is for pension matters, lordship.
Wednesday. 27th.
Please, your lordship. I beg to mention with the consent from the other side, item number 8, your lordship. We would like to file an IA in the matter. So, kindly adjourn the matter for this.
Item 8 on the request. You are for the petitioner.
Yes.
And for the
The petitioner submits that the. Oh, I for what?
There is subsequent development has happened in the matter.
6. Liberty to file additional pleadings by way of an I. Prayer made is not objected to by the counsel for the respondent. Matter stands deferred to Mr. Dar.
1 of June.
Please from 19th
ID.
June.
Item number 17, your lordship, adjournment slip was circulated yesterday.
Item 17 on the basis of the adjournment slip circulated stands deferred to be listed after.
So, lordship, I beg to mention one WPC matter for listing. Lordship. This is regarding pensionary benefits.
Wednesday, 27th.
Yeah, please, your lordship. I beg to mention item number 9, your lordship, for adjournment. I have informed the counsel from Maintainability department.
Item 9.
Yes.
Counsel for the petitioner stands 6 an adjournment for item 9. It is submitted. Consent of the counsel respondent has been obtained. Please take accordingly.
May I please, lordship? Lordship, I beg to mention item for listing. One lordship had allowed listing on Monday, but it came in yesterday. But it came before a court matter which couldn't take it up. Matter. So, transfer matter, my lord, should kindly list it on more if possible on Monday. Same CRPF transfers. My lord had allowed on Monday.
It was allowed for Monday.
No, it was allowed on Monday. I mentioned it was allowed. For yesterday, it was listed.
25th.
Monday, man.
Please, your lordship, I beg to mention a fresh section 11 arbitration petition.
When was it filed?
Lordship, yesterday. Lordship,
Come on its own. Why do we have to
lordship, only one aspect. I have obtained interim relief under section 9 from the Learned Trial Court. That matter is fixed on Monday for extension of the interim relief. So, because the 30 days period gets triggered only on that.
Right, tomorrow.
Public.
May I please, your lordship? Lordship, I pray for listing of WPC matter for admission. It is a service matter, lordship, and it was last listed on 11th of March. And it was supposed to be listed on 4 weeks, but it has not been listed since.
27th.
Yeah, please, lordship. I beg to mention item number 14 of
14.
yes, with the consent of the other side. Your
And
lordship.
for the other.
Item 14 stands deferred to be listed after 2 weeks.
Very small. Drink comes from Kolkata.
Let it be in July because there will be
After
summer vacation.
Yes, after vacation.
After vacation, you make a mention, fix a date.
Please, your lordship. I beg to mention for listing of my arbitration petition. Any day, your lordship, as per the convenience of the court.
Wednesday, 27th.
Lordship, lordship, I beg to mention for listing of contempt case, lordship, for orders, lordship,
Roders, 27th.
obliged, lordship.
In this matter, we are supposed to file an affidavit, but those documents which were supposed to be brought on record, those are awaited. Your lordship may grant me for the 2 weeks time.
Yes.
Lordship, as per last order, Lordship, they are supposed to bring the regulation orders, and also, Lordship, 3 petitioners were not regularized. There, if any rejection, Lordship, that order also be.
On the request made by the counsel for the PNRD, requesting for further time, matter stands deferred to be listed after 2 weeks. Mr. S.K. Sinha appears for the petitioner. This matter again on 10th,
10th of
10th of May.
Obliged, Lordship.
Thank you, the Lordship. Lordship, we would like to file an affidavit by today itself and provide the service copy to the petitioner.
On whose behalf? APDCL.
Mr. D. Chaudhary.
You are appearing for APDCL.
Yes.
Counsel appearing for APDCL submits that they would like to file an affidavit during the course of the day. They submitted, then the matter be relisted on some other date. Well, considering the submissions made, is this matter after 2 weeks, by which time the petitioners may also file their rejoinder if so advised. After 2 weeks.
May it please my lord. My lord, consent has been received in this matter. My lord, counsel Mr. Bigugu is in each of a part matter.
What has been received?
Charge sheet has been filed against the petition has been received by the conducting counsel, my lord. And so he's appearing in this matter. He's in the midst of a part matter in another court in the bench of this court.
After some time?
My lord.
After some time.
Please, your Lordship. Should kindly pass over the matter for the time being.
Yes, madam. Timely. All right, timely.
So argumentation, Mr. PK is on legs after some.
Every matter can be after some time. What is this?
Court number 2.
Whatever it may be, this is also a court. What do you think this is? You are there, you argue the matter. What is this? Every matter after some time. Yes.
My lord. Yes, sir.
Yes.
My lord, the petitioners here were appointed as the direct recruits to the sub-inspector in the year 2010. My lord, it's at page 36. The appointment letter. My lord, the respondent number 5 herein, whose appointment, whose promotion I've been challenging, was appointed as constable in 26/5/1990. My lord, his appointment order is at page 52. He had filed a writ petition and the annexure of it is at page 52.
Yeah, carry on, carry on. Yes.
Yes. So my lord may hear, my lord may see the following ABL NK constable of different unit are selected for promotion temporarily to officiate as Havaldar clerk so and so. And my lord may find the name of the private respondent at page number 57. 58, my lord. Is at 1 second, my lord. And my lord may see the serial number. It's 184. 183 is the top and then 184.
57.
Yes, ma'am. 58, ma'am. 58. Tapan Kumar Mohanto, my lord. 13th Battalion, 14th APN. Then, my lord, at page 60, my lord, he was promoted from Havaldar to ASI clerk AB. My lord, now at this type copy at second paragraph, I may read, my lord, they may be released, promoted accordingly
their inter se seniority will be counted along with their batchmate in the rank of Havildar clerk for their promotion to the rank of ABGI in the due course. Will be counted along with the batchmate in the rank of Havildar clerk. My lord, surprisingly, whose name was at serial number 184, came up at 53, which was not as per the order. My lord may see, they may be released promotion accordingly. Their inter se seniority will be counted along with their batchmate in the rank of Havildar clerk for their promotion to the rank of ABSI GD in due course. And my lord may see here at page number 61, respondent number 5's name came at second. From 184, he directly jumped to second, my lord. And even in the order, it has been mentioned that they may be released, promoted accordingly. The inter se seniority will be counted along with their batchmate in the rank of Havildar clerk for their future promotion, the rank of ABSI in due course. Now, thereafter, my lord, he was in 2000.
What is the prayer? What do you want?
My lord, he was the order that I have been setting for prepared for set aside is at page 101, my lord.
What is that order?
My lord, it is at Annexus 6, which said that the inter se seniority pursuant the representation of Inspector Tapan Kumar Mohanto of Commandment so and so, the inter se seniority in the rank of ABCI has already been restored by this headquarter dated 31/7/2017, conveyed by memo number so and so and order dated so and so, with effect from 9/10/2019, where a junior Havildar clerk was promoted. The inter se seniority in the rank of ABSI, as per government instruction dated 2/6/1961, provides that in normal course of seniority, the batch appointee promotee on the promotion to the next higher rank is determined on the basis of the seniority in the substantive rank. So, claim of Tapan for restoration of seniority is entertained above Akhir Ali, who was promoted to the rank of Inspector Police, conveyed with so and so, and his financial benefits. I am challenging this order without any DPC being done and without following the due process of law. He has been given inter se seniority without following the criteria that for a sub-inspector, he has to have 5 years of service. That has also not been followed, and he has given me this promotion, my lord. And by giving this promotion, we the direct equity of sub-inspector of 2010 batch, he has jumped above us. My lord, this order was passed after this High Court judgment, which is at page 96, Annexure 5, where the petitioner herein had directed for his promotion, and the order, the effective part is at page 98.
Who filed the writ petition?
My lord, the respondent number 5 here.
You have not made a party.
No, we have not made the party.
Then,
So-
did you file an appeal or a review?
No, my lord, we did not file a review because thereafter, automatically, my lord, this order was passed. My lord, the order was on 24/5/2022.
Show us the direction of the court.
Yes. The direction of the court is at page 11, my lord. Page 99, paragraph 11. Considering the submission made by the learned counsel for the parties and keeping in view with the facts and circumstances of this case, this court is of the opinion the petitioner should be given liberty to file fresh representation to the Director General of Police Assam, highlighting his grievances. However, keeping in view the fact that no notice has been issued to respondent number 5 in the instant case, this court is of the further opinion the concerned authority should dispose of the petition representation to be filed by him only after an opportunity of hearing is given to the respondent number 5. In view of the reasons stated above, the petitioner is given a liberty to file a fresh representation within a period of 2 weeks from so and so.
Who is
Respondent
petitioner number 5?
Respondent number 5.
Respondent
That's
five?
Akhir Ali.
No.
Rajveer Singh, my lord. Rajveer Singh. That's not me. I am the petitioner.
Is he a petitioner here?
No, my lord. He's not a petitioner here.
Okay.
So, my lord may see, interestingly, this order was passed on 24/5/2022. The judgments of this honorable court was passed on 24/5/2022. And the order which I have challenged was of 21/5/2022. And this was not brought to the notice of the Honorable High Court. If this should have been brought to the notice of the Honorable High
You
Court,
should have filed a leave.
my lord,
to
I was
review.
not a part. I was not a part of the
You
representation.
can file a leave to review.
No, my lord, I did not have any right on there because my lord, my right had been affected only after coming of this order. So the fresh cause of action has already been borne by that time, my lord, because they have already came up with a notification that is on 29/7/2026, where my name was, where my candidature and the candidature of the representation I represented have been given below. And thereafter, my lord, I had filed an IA for a provisional seniority list where there is an order of this court that this had to be stayed
IA file where?
before this honorable court, my lord.
In which matter?
In this matter, in IA 189 of 2024, and the file is here.
Yes.
And that was disposed of on 28/2/2024, where it had been stated that by this application, the applicant is praying for keeping in abeyance the provisional gradation list published by respondent number 4 on 9/1/2024, placing the name of respondent number 5 in serial number 2 above the petitioners.
Which gradation list? Page number 102.
My lord,
Which gradation list is to be kept in abeyance?
my lord, the gradation list was in the IA, my lord.
Not here. What is this at page 102?
That is the gradation list of the confirmed. That is the gradation list of the which was final gradation list.
Yes, then
So the provisional gradation list, my lord, thereafter was stayed.
provisional gradation list for which post?
My lord, for the promotion to the post of inspector. My lord,
Provisional gradation list in which post?
my lord, the provisional gradation list for the promotion to the post of inspector, my lord. The promotion to the post of inspector, my lord. That is at the IA, my lord.
Is it for the Havildar or for the inspector? Which gradation list?
For the Havildar, for the post, for the promotion to the post of inspector, my lord.
Okay.
Gradation list of inspectors, my lord. The petty respondent here one started from Havildar.
Page 102 is the final gradation list.
My lord, page 102 is the list.
You're not prepared.
No, my lord, I'm prepared, my lord. I'm just placing the fake. My lord, I would like to
102 is what? Which gradation list?
My lord, that's a gradation list that was published in 29/7/2021.
This is the final gradation list.
No, my lord, this is not 7/7/2022. The list was there. The provisional gradation list I had challenged.
And what is this gradation list that you enclosed?
My lord, that is where I was command. My lord, let's just look at the IA first, then my lord will be clear. That's what.
Why don't you answer the question simple, straight and simple?
Yes.
What is this gradation list that you have enclosed? 29/7,
My lord,
21.
but this
This is
gradation.
a gradation list of Inspector AB.
Yes.
Ah.
So, my lord, by this gradation list, what had happened? The respondent number 5 had marched above us. So we have challenged this gradation list,
All right.
the final gradation list. And in between, my lord, I had filed an IA where the provisional gradation list was also been there. My lord, that may be checked, my lord, and that had been taken, that recording the submission of the learned AG, the interrupted application was disposed of on the ground that the provisional gradation list would not be finalized till disposal of the main writ petition 1525. That is this one. So, my lord, when the provisional gradation list had come, I had given an objection, and after I had given the objection, I had approached the court, and after the approach of the court, on the instruction of the AG, they have said that the final will not be finalized. So, as such, my right as of today has been protected. Am I?
You're not clear.
My lord. My lord, at page 95.
There, the IA order says that provisional list shall not be finalized.
Yes, ma'am.
Till disposal of 1525.
This is this one.
Which is 1525?
Yes, ma'am.
Huh? This is 5694. You're not prepared. List next week,
No, my lord.
enabling the petitioner to apprise the court properly. Yes.
I have started that number 5, my promotion is being hosted because of this matter. My juniors have already been promoted.
Yes, Mr. Go tell us.
This cause of action arise from the order dated 21/5/2020,
Passed by whom?
passed by the Inspector General.
Page number
Case number 101.
101, okay. Now his grievance is that the seniority has been rearranged in such a manner that this respondent 5 is gone above.
Your Lordship, the DPC was held, review DPC was held, and accordingly, they under the recommendation of the DPC.
Where is the DPC minutes?
But there is no DPC meeting.
Where is the DPC minutes?
Your Lordship, at present, I am not holding.
In the feeder category of Havaldar, he was senior.
Yes, Your Lordship.
He was senior.
Yes, sir.
Then there was a promotion.
Yes, promotion.
So who was earlier promoted? Respondent 5.
Yes, he had responded of 5.
5. Then the petition.
They were directly recruited. They were recruited in the year 2010.
Right.
And they
Recruited as inspector.
as a sub-inspector.
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 And the private respondent was promoted
Promoted as
From the
sub-inspector in the
post
2009.
from the post of Havaldar.
Havaldar.
Now,
Then he was promoted to
under the
inspector.
rules between promotees and direct recruits,
The promotee always gets the
promotee will get the seniority.
Seniority.
Now, there is a gradation list. Gradation list was apparently stayed by an order in the IA.
Yes, my lord, the
In disposal of the writ petition
Yes.
mentioned therein.
Yes.
my lord, the writ petition number has been wrongly reflected. Otherwise, it's this IA was linked with this WPC. While the order, it is a 5694. That is where the confusion came in. Otherwise, the facts which I have laid is correct. My lord, may
During the pendency of the writ case, this writ petition, there is an interim order that it should not be finalized.
We have not yet finalized the unit.
Then what is that 102? Yes.
Yes, it is on list of 27/2021, page 102.
Hmm?
Page 102, gradation list is gradation list of inspector of police.
This is final or is this the final gradation list? Huh?
Published in the year 2021.
Then how do you published it in the course of the interim order being the currency of the interim order? How was it published?
102 was published prior to passing of the interim order, madam. In the year 2021, madam.
Right.
my lord, may I just submit him? That's what I'm, my lord, this 27/7/22 was after the order of 21/5/2022. And my lord, in this can, my lord may come at serial number 35, where the respondent number Topon Kumar Mohanto is there, my lord.
Page number
Page number 103.
103. Yes.
Here, my lord, Topon Kumar Mohanto, Nolbari, not confirmed, seniority fixed. Date of confirmation is not confirmed, my lord. And his seniority is fixed. And this is a replication of the order that is of 21/5/2022, where his name was given before Akhir. And by doing so, my lord, this gradation list, we have challenged it because it has affected our rights.
What does the rule say?
The rule, and thereafter, my lord, they came up with a new provisional list, which I have challenged in the IA, and that is on standby. And now what? And now the gradation list, which has to be marginalized after he has come into the effect, that in that my name has to be there before him. So this was a list which was on 7/7/2022 after the consequential order of this 21/5/2022.
Where is that order?
My lord, that order is at Annexure 6, page 101.
No, no, you are saying this 101 order is a sequel to the order passed by the High Court.
No, it was High Court order was on 24/5/2022.
This was prior to that.
Prior to that, and they did not bring this order before the honorable judge, and this order stand. And moment this order stand, what did the department did? They put his name at serial number 35 before Akhir Ali, without any DPC being done, without following the due procedure law, and by doing so, they affected my seniority.
Where is your name?
At 149, my lord, 107.
And according to you, his name should be where?
My name should be above Tapan Kumar Mohanto. We are the direct equities, so we should be promoted at
So show us what
2010.
Show us what the rules say.
My lord, the rule. Police manual, my lord.
Police manual.
Yes, ma'am. Page 258.
258.
Yes, ma'am.
Yes.
Promotion to the rank of inspector, my lord. Clause 39.
We have some different 258. What is this? Name of the act rules?
My lord, reserve order. This will be
Police manual contains the Police Act.
part 3, my lord. It will be part 3. Assam
Part 3.
part 3 rule 39, my lord.
What is the part 3?
There is no part 3 here.
My lord, in fact, I have replicated the thing in my reply.
Give us a copy.
No,
Let us
this
have the
is
benefit of going through the
My lord,
rules.
there is no online copy. That's why I had to buy this.
You have to buy books. It can't be so painful.
No,
Why you saying with so much of remorse? You're buying books because you're a lawyer.
no,
You have to buy
I'm
books.
saying that there is no online. That's why I
So you have to buy books.
no, I had to.
Otherwise, you
bring
would
the
have bought a
book.
laptop or
No,
a
Even I
iPad.
had to bring the book.
You should have bought another copy for the court also. Yes, tell us which rule.
So, my lord, rule 39,
39.
where it says that if a person has to be promoted to the post of inspector, he has to have a 10 years of service in the post of sub-inspector. Proviso below, my lord.
Yes.
Whereas the respondent number 5 here, he does not have a 10 years of service in sub-inspector.
What are these rules? These are not the service rules.
These are service rules, my lord.
Hmm.
These are service rules, my lord. This is, my lord, the reserves, ordinance, clothing and guards and escort from part 3 of Assam
This is
3.
not the service rules.
My lord, these are the service rules. These
No,
are the rules which will, these are the rules which will.
Where is the cadre mentioned here? What is the cadre?
My lord, he is a.
Where is the cadre under the rules?
My lord, my lord, business. My lord, rule 11, it is direct recruitment of sub-inspector. Every superintendent of police will maintain a list of candidates for direct recruitment of sub-inspector. That is us.
You give the rules, we'll make copies of, we'll take it up after a while.
I'll just bring the copy.
No, you don't have to. You give it to the court master, they will get it for you. You to Lolo, copy the. We'll call it up after a while. Yes. Yes. It is a lawsuit. This case, one of the petitioners could not challenge the departmental proceeding and initiated against him, my lord. The charge. Where is the charge sheet? Charge sheet. Charge memo. Will file at page 57. Basically, three allegations, my lord. Third one only two has been detected. Till case number one was added. Says that my family has more than 1 kotha 10 acres of land in Gauhati, and the built up area of the RCC building is 6168 square feet. So I am not eligible for EWS category. This the allegation. So you may kindly see the sale deed by which my father passes the land. So we are not deciding on the issues. Just want to see what the charges are. You had been recruited on the basis of EWS. Right. And what are the charges here? We are also, this, apart from these two charges, they have added one more charge that my family income was above 6 lakhs. And the notification for EWS, it says that the family income should be, initially it was said 6 lakhs, subsequently it was amended and it was enhanced to 8 lakhs. They have not considered the subsequent enhancement as well as the income of my brother, that is also counted. That cannot be counted as per notification. Above 18 years of age, whoever siblings are, their income cannot be counted. Notification says so.
Lordship will see page 20 onwards
20 of
the criminal
charge sheet. Yes. The A is my father. He had the income of 6,32,273. And income of my elder brother, that has also been counted. That cannot be counted as part of notification. So the disciplinary proceeding charges are also similar.
No, why I'm saying is, so far the disciplinary proceeding is concerned, Lordship has already perused the charge number 1. The charge is, why he should not be terminated for entering into service with a EWS certificate, which otherwise is not eligible. Now, so far as the charge in a criminal case is concerned, there, only his involvement in procuring the certificate will be examined. The veracity of that, EWS certificate will not be examined in a criminal case, That is what I said in the last occasion. He has not challenged the report, of the district authorities who has submitted that, he is otherwise not entitled. because of this condition. They do not fulfill, he did not fulfill the requisite qualification for having a EWS certificate. One, the land part. Second, the square feet of the building, which as per the norms, it should be not more than 1,000. Here it is 6,000. So even we don't consider income part. That is what has been examined by the authority, in this DP. Whether he will be allowed to continue. Even he succeeds in the criminal proceeding, that he has no involvement in issues of that particular EWS certificate. Then also the EWS certificate is not
report is not under challenge.
not under challenge. Not in the present
report as such, my lord. They have directly, my lord, lodged the FIR.
No. There is a report of
There is
the
a report.
circle officer. There. Circle officer's report is there.
Circle officer, my lord, they
My lord, in the FIR itself at page 27, para 3. Then para 6.
There are communications from the circle officer. Report of the circle officer. Dated 13/6.
They have affirmed that they have issued the certificate. It's not that they have said that they have not issued the certificate. After my application, they have issued the certificate. This is not a fake certificate. They have affirmed that. Have there been any allegation?
No. The question is not whether it is fake.
Genuine.
Question is whether this has been, whether you are entitled to it in terms of the SOP. That
Yes.
the requirements,
My lord.
whatever is there.
My lord.
Now, the case built up against you is that these are out and out violating of the SOP.
That is said by the police officer, not by the circle officer. And I guess on the basis of that FIR, my lord, and charge sheet has been laid by the.
What is the stage now, Mr. Gogol?
My lord, the certificate has been submitted. Thereafter, my lord, the trial has not been initiated.
Charge has been failed. Copies are not also furnished. My limited prayer is this, my lord. As the prayer, as the allegation in both the criminal and the
Let it be stayed till the charges are framed.
My lord, that is my limited prayer.
Let the charges be framed. If at all. He is entitled to file an application for discharge and whatever you want. Till then.
But even, my lord, this Shenzhen, my lord, that case, my lord, 2014 3 SCC, which the petitioner is relying upon, that is stayed for a particular period. There also, my lord, the issue was different, man. Lord Civil, my lord, see, my lord, while considering this sort of cases, we will see the gravity of the offense, my lord.
Correct. But here he is under suspension now.
He is under suspension.
So here the charges which you have framed are
not suspended.
Where are the charges? Page number?
My lord, yes, it's at page 50.
Page 40,
57.
57.
57.
That he's the owner of so-and-so property, and as per SOP norms, he's not entitled.
Yes.
That is the charge.
That is the charge.
So this will it not require a finding that whether the SOP has been violated, not violated? There has to be some finding. There's a report. Who decides on that? Who decides whether the SOP has been violated or not violated?
From the evidence available regarding the land as well as the building.
Will it be decided in a criminal case?
That's what I'm saying, my lord. He has not taken any steps.
I can prove that these allegations are baseless. From the report in the petition, my lord, I can prove that these allegations are baseless, because, my lord, they have considered the Jamabandi, where the land has been recorded wrongly. against which, my lord, my father has also, my lord, submitted an
You
application for
challenge
correction.
you challenge the report
No,
of
no,
the
but-
circle officer.
Circle officer has not reported that they have not issued the certificate. They have issued the certificate falsely, my lord. They have not reported that, my lord. They have, my lord, reported that they have issued the certificate on an application made by the petitioner.
No, but circle officer report will also contain what land belongs to you and what does not.
My lord, if we consider the sale deed, my lord, sale deed is the, my lord, actual
Where is the SOP?
SOP loss will find at page 30, my lord. 11 portion, my lord, page 33.
Yes.
33.
Roman
conditions.
1.5 kata land notified in the municipal corporation, municipal board, town committee area. That will be applicable in case of the petitioner, my lord. And if you also peruse the sale deed says that, my lord, my father purchased a plot of land, my lord, measuring 1.10 lesser.
Let us, I think,
1.10 kata.
there will be more clarity once the charges are framed.
Fine.
So till then, let the proceedings be stayed.
My lord, he can prove the same before the DP also, in the DP also, my lord. He can
Let it-
prove it before
let it
his
be-
honorable court.
let
Same
it be
thing he is
stayed.
disclosing, my lord.
Let it be stayed till the charges are framed.
In the case, my lord, I have given the copy, my lord. Same
that-
thing has been
that-
done, my lord, laying down the, claiming the charge, my lord. Procedural state.
The charge sheet is filed, so process for framing the charges must be underway. When was it filed?
It was filed on, my lord,
8/4, at least the copy was.
Yes, sir.
7/4/2026, my lord.
8/4/26.
7/4/2026.
7/4/8/4.
7/4/26, my lord. The
It was put up on 8/4.
Put up on 8.
my lord.
Let the charges be framed. Yes, Mr. Gugoi. That will make things more
Lord,
clear.
I've gone through this judgment of 2014 3 SEC. There, my lord, this was different, man, totally different. The charges were grave, man, in the criminal case. There, my lord, the proceeding was stayed in the initial stage by the
See,
High Court. Then it
You
went to the
you are proceeding against him on the ground that he is not entitled to have the benefit of EWS
Man.
certificate, which he has obtained.
minor.
Admittedly, from the materials available, report of the circle officer and all, that they have issued the EWS.
Minor.
Correctly, incorrectly, they have issued the EWS.
Minor.
Now, the only question remains is to see whether this EWS is entitled to this benefit or the SOP or the norms which are there. This will require some finding.
That, my lord, trial court will not, my lord,
Not do.
consider. Yes,
Not do.
that's why.
But the fact remains that the question, the charges that the charge sheet which has been filed and what ultimately charges are framed will be relevant to decide whether he is going to be prejudiced.
I don't know, my lord, that will help the petitioner. So charges, my lord, is on the criminal angle only, my lord. What is his involvement? He
That
has not challenged the FIR, my lord.
That
my
will
lord,
depend on what charges are framed against him, which he is supposed to
Because, my
defend. From the charge sheet, we can't say that all the charges will be accepted. May not be accepted.
why not? In that case, also will have a consider my affidavit also, my lord, particularly para 6. Also, kindly deal with that. Because
There are
we
6.
Yes, we have filed a detailed one. Including, my lord, placing certain judgments and all. On this point, whether parallel proceeding can be drawn or not.
Of course, it can be.
Yes.
There is no
So,
doubt.
my lord,
There is no doubt on
there are
that.
judgments on both sides in this regard. Because if you can disclose it, my lord, before this honorable court in the writ petition, why can't they disclose it before the departmental proceeding authorities, my lord? Only you will have to prove that, my lord, this particular land is, my lord, not above, my lord, 1.5 kata. It says over the square feet of the building is about 1,000 square. Then we'll have to
Yeah,
prove
how are you
how
going to be
this will
prejudiced?
affect it.
How are you going to be prejudiced?
Yes, sir.
Minor,
He will have to save his job here.
But defense is there, my lord, I will have to-
Defense in respect of what? Charges?
In respect of the charges. my lord.
What charges?
In respect of the charges that my lord, I have obtained the EWS certificate, my lord.
You don't deny that.
I have obtained the certificate, my lord,
You have
but
obtained.
there is no
The report also
irregularity.
does not say so.
There is no irregularity in obtaining the certificate.
Hmm.
That is my case, my lord. The process on by which, my lord,
The charges against you in the departmental proceedings are, you are not entitled
Fine.
to the benefit. This is not the criminal charge. Charge before the criminal, in the criminal proceeding, charge sheet which is filed, these are not the charges.
in the criminal case also, my lord, the same charge is there, my lord. They have, my lord, I have obtained the, my lord, certificate, my lord, by showing false document or, my lord, by.
That's right. But whether you are entitled or not, is the false document, etc., is not a charge in the departmental proceeding.
No, my lord. On this too, he have to show that, my lord,
If
it is
if
below 1.5.
there is no irregularity in obtaining the certificate, my lord,
Hmm.
then, my lord, departmental proceeding will have no consequences, my lord.
Therefore,
That will be decided by
Therefore,
the
why
trial court,
stay
my
it?
lord. But that will be decided by the trial court. Validity of the, my lord.
why stay the departmental proceeding in the face of the charges against you?
My
Look
lord,
at the charges again.
Page 58, 57.
Look at the charges again.
my lord.
Is as per the SOP, you are not entitled to have so and so land, then building.
My lord, then,
Therefore, you are charged securing by producing fraudulent.
and record is there before your lordship, my lord. The sale deed, they have, my lord, recorded wrongly, my lord, in the Jamabandi, and that has been considered without considering my sale deed by which the land was purchased. In the sale deed, my lord, it says, my lord, the land measuring 1.10 katha, 1.5 katha. And the income of my brother has been, my lord, counted. And my
We are
lord,
staying it. Heard Mr. Ayat Sokhel and counsel for the petition. Petition is fine. Challenging the departmental proceedings initiated by the show cause issued to the petitioner by the communication number so and so dated 3/08/2025, page number 57. It said, show cause notice, the following charges are framed against the petitioner, charge 1, charge 2. Correct. On the basis of a complaint lodged before the vigilance department, an investigation was undertaken, and the vigilance department has also registered a case, being vigilance case number 19 of 25, and in the said matter, the charge sheet was filed on 7/4/26. Charge sheet number 6 of 26, dated 7/4/26, and cognizance of which was taken on 8/4/26. So the matter is presently at the stage of framing charges, the competent court, criminal jurisdiction. Learned counsel with the petitioner submits that considering the charges leveled against him in the departmental proceeding, if he is compelled to participate at this stage prior to the framing of charges, during the pendency of the criminal matter, he will be compelled to divulge his defense before the authority, which will ultimately may prejudice him during the trial. Well, the petitioner therefore submits that during the pendency of the criminal proceedings, the framing at the departmental proceedings be stayed, which may be resumed only after criminal proceedings are concluded. Stop. Further submits that the very basis of initiating the departmental proceedings is the premise that that he had submitted false documents before the concerned authorities, and only during the trial these findings will it's only during the trial that such findings, correctness of the allegations can be cited by adducing proper evidence. Per contra, Mr. B. Goyal and additional lady strongly objects to the submission. What judgments you are relying on? He is pressed into service. An order of the coordinate bench passed in WPC 321/24 dated 5/2/24, and has also relied on the judgments rendered in Eastern Coalfields reported in so and so, and Stengen Toyotets India Limited reported in so and so in support of his contentions.
Possibly record my
Par contra.
well, 1996 6 SCC 417.
Huh?
1996 6 SCC 417.
1996
6 SCC 417.
17.
And other is one of 1999 3 SCC 679.
1999.
3 SCC 679. That Paul Anthony Money.
96 is Paul Anthony.
99 is Paul Anthony.
Paul Anthony. And the other one?
Otherwise became Ina.
And 96 is BK Mina.
Yes, ma'am.
Mr. Gogoi, learned additional AG, strongly objects to the submissions made by the counsel for the petitioner. He submits that the criminal, as in the present proceedings, there is no challenge to the report of the circle officer or
the
FIR, or is there any denial by the petitioner that he did not apply for the EWS or did not rely upon any EWS certificate. So rather, he admits that he had applied for and has relied upon EWS certificate. The circle officer's report also gives a finding that the EWS certificate was applied for on the basis of the documents, and accordingly the certificate was issued. Therefore, the department has decided to proceed by issuing the charge sheet show cause memo. So, if the petitioner is able to dispel the allegations made in the departmental proceeding, it will ultimately help him in the criminal proceedings. So, he further submits that there is no dispute with the proposition of law that departmental proceedings and criminal proceedings can be initiated simultaneously. So, referring to the judgments rendered in DK Mina reported in so and so, Paul Anthony so and so, he submits that it is only in cases where there are serious allegations, where the charges are very grave, that the departmental proceedings are stayed during the currency of the criminal proceedings. So, in any view, he submits that in any view of the matter, unless the petitioner makes, unless there is a finding by a competent court of law that the petitioner had applied for the EWS certificate in terms of the SOP and the parameters prescribed. Such findings will not be returned by the criminal court, by court of competent jurisdiction. He therefore submits that this is not a case where the departmental proceedings should be stayed pending criminal proceedings. There are counsel for the parties have been heard, pleadings available in the court have been perused. The judgments cited at the bar have been carefully perused. There is no quarrel with the proposition that departmental proceedings and criminal proceedings can proceed simultaneously. It is only where the court finds that compelling the delinquent officer to proceed to divulge his defense before the departmental authority may prejudice the officer in his defense before the criminal trial, that such departmental proceedings are normally allowed to proceed. So, in the perusal of the memo of charges, you can see that the following are the so and so charges. The charges leveled against the petitioner in the charge sheet which is filed before the criminal court are yet to be framed by the court of competent criminal jurisdiction, namely the court of special judge Assam. Stop. Therefore, as on date, the charges which may or are likely to be framed against the petitioner in the criminal proceedings are not before the court. Therefore, at this stage, it is not clear as to whether the charges likely to be framed against the petitioner, framed or likely to be framed against the petitioner before by the special judge in so and so case would be one and similar to the one framed in the show cause notice issued by the department. Stop considering the present status of the criminal proceedings. This court is of the view that until the charges are specifically framed against the petitioner, prima facie it appears that the charge number 1 in the charge memo and the defense which the petitioner may be required to adduce before the departmental authority may have some bearing in the defense which the petitioner may be called upon, will be permitted to adduce before the criminal trial in so and so case. For such circumstances, this court is of the considered view that the departmental proceedings initiated by the charge sheet number so and so shall be kept in abeyance still the charges are framed in criminal trial number so and so so and so. Stop. The counsel for the parties are directed to apprise the court immediately upon the charges being framed. So, copy of this order be marked to the Court of Special Judge Assam in connection with so and so, who will send a report, the registry of the court, immediately upon the charges being framed in so and so. Thereupon, the matter be placed before the court accordingly. List again after
So this is the claim.
8 weeks.
Or my lord, she will say, my lord, after.
List the matter after report is received from the Court of Special Judge regarding framing of charges. End of legal discharge of the petition.
Lordship, I translated the statements.
Your Lordship
statement.
has substantially heard the arguments. The records were required to be translated by my learned
I
friend.
have already translated.
These are the translations.
Will I not be entitled to a copy of the translations? I'm just
Yes, of course.
seeking
you
your
will.
Lordship's permission.
Yes, yes.
What in Hindi or English?
Anything. I'm okay with Hindi as well, Lordship.
She is
Whatever.
more proficient in both the
No.
languages.
No, since I have produced the record, Lordship, so I have not supplied. Lordship, that may be supplied.
No, we are not directing them to supply anything. We are saying that if the council wants to go through,
Yes, Lordship. I have not.
I'll be with you.
Lordship, statement of petition is also there.
Hmm.
Statement of the petitioner recorded by the beneficiary.
let us keep it for the second half. We'll require some time
Lord,
to go through. Meanwhile, you can share the copy.
I have already given.
Yes.
Could I be accommodated with 2:30? Subject
Yes,
to
yes.
that.
After 2:30.
I'm deeply obliged. Lord.
We'll have it at 3 o'clock.
3 o'clock.
Lord.
Deeply obliged.
Timing item 5.
Yes.
My lord, in the instant case below, the petitioner initial prayer, my lord, seeking the correct fixation of his basic scheme. He dated from 31st March 2017. According to 2019, he filed the instant writ petition, my lord. And the pleadings complete 2024, respondent filed.
You are serving.
Yes,
You're still serving.
Yes, my lord. My lord, no, I'm retired.
You're retired.
31st March 2017, my lord. Now, my lord, for the first time, my lord, on 28 August 2025, the question raised regarding maintainability of the writ petition, my lord. Since the
Right.
total, yes, my lord. 28 August 25, order kindly have perished.
28 August.
Yes, my lord, 25.
Yes.
In the light of this order, my lord, since whether my case is maintainable before this honorable court or not, whether since Central Administrative Tribunal, as per Section 14 of the Administrative Tribunal Act is there, my lord.
Let us see Central Administrative
Yes, my
Tribunal.
lord. My lord, lordship, kindly, this book.
Yes.
Yes, Section 14, the bar regarding the
Recruitment, matters of service. You served under
water resources, water
union.
Union. As I dated as work shortcut grade 2 minute in the year of 2017. So, Mother, from this section, it is goes below that the alternative remedy is before the Central Administrative Tribunal,
Hmm.
and I preferred the instant petition in the year 2019, I dated 2017. After pleadings complete, the event from the respondent side also not raised this point of regarding maintainability of the question in this matter, So suddenly on this occasion, 20 August 25, the alternative forum
What
is
do you
there.
say, Mr. Thompson?
Lordship, Honorable Court has the maintainability question there, Lordship. Matter will go.
But pleading is absolutely silent on their party, because they never raised any question
Question
on
of law not
maintainability,
required to be made. Lordship.
And my
This is
only
the Honorable Court has paused in the question, Lordship, regarding the maintainability of this.
at
case.
this stage,
Rightly.
yes.
Yes.
at least my respect will submit before this honorable court, my lord. First of all, my lord, this admittedly, my lord, it is true, my lord, that alternative of forum is already there, my lord. The lordship, my lord, the application under Article 226, my lord. When lordship can invoke the right of this, despite the available alternativity, the fundamental rights violation must be there.
What grounds are you urging?
On fundamental rights, I have.
What fundamental rights?
My rights is fundamentally rights has been violated.
Your question is that you are asking for a pay revision.
Yes. Pay revision, my lord. My basic pay was, they have
You're asking for a pay revision.
pay revision.
Isn't it?
Yes, my lord.
According to you, you are entitled to that. Now, you ought to have filed before the cat.
My lord. I therefore am submit, my lord. Certain
In view of L. Chandra Kumar.
Yes. My lord, my lord, this honorable division bench of this court as well as honorable apex court after L. Chandran's case, my lord, that's also relied the L. Chandran's case. I have. And in this regard, on maintainability, my lord, I have filed one additional affidavit. Paragraph 4 and 5 may be considered. I filed on my additional affidavit on 11 September 2025, my lord. First, I'd like to draw your lordship the kind attention, my lord, that is Maharashtra Chase Association case, my lord. Paragraph 19 and 20 and 22 and 23. Paragraph 19. Marriage amendment. Yes. This argument of the second respondent is misconceived. The existence of an alternative remedy, whether adequate or not, does not alter the fundamentally discretionary nature of the High Court jurisdiction and therefore does
You
not.
tell us what is the facts. What are the facts here?
Here means a similar question raised regarding alternative.
Similar question on what facts?
What is the High Court's power, my lord? What is the High Court's power? When High Court can invoke the right, my lord?
In what
My
facts?
my case is little different, my lord.
What facts?
That is the, my lord. This is state, my lord. Paragraph 2 it is discussed, my lord.
You are pointing out to the legal issue without referring to the facts.
Regarding the principle, my lord, what discussion they have made, I am relying on that, my lord. Whether
you are relying on a principle without referring to the facts.
Does it come to the page paragraph 2, my lord?
Yes. Read paragraph 1.
Yes. The present appeal raises the issue of what the private agreement entered to the party between the appellants and the second respondent in the form of constitution and the bylaws of the latter camp. By conferring the exclusive jurisdiction on the court at Chennai out the jurisdiction of the Bombay High Court, Article 226 Constitution. The clause 20 in Constitution and bylaw of the second respondent is as follows. This is a legal course. This is number 3, my lord. The second respondent and all Indian Chase Federation is a society registered under the Society Registration Act. It is central governing authority of Chase in India. The appellant is a society registered under Act and was an affiliated member of the second respondent.
Come to para 8.
Yes.
8.
The Constitution and the bylaws of the second respondent are a private agreement between the appellant and the second respondent. The decision of the Bombay High Court relied solely on the clause 21 to hold there its own jurisdiction and the jurisdiction of all other courts is ousted. Whether the private agreement can be ousted in jurisdiction and the High Court merits further inquiry. And it is a well settled principle of contract law that the parties cannot be by contract exclude the jurisdiction of all courts. Such a contract would constitute.
Is this a private jurisdiction? Private contract?
That is the dispute, my lord. No. This is my case is not private.
On those facts, it was rendered.
Why am I relying that?
You are relying the principle that notwithstanding jurisdiction not been there, you can entertain. The question is, here it was on a private agreement where the jurisdiction was
absolutely, absolutely.
But this statute is not a private jurisdiction.
No,
private contract.
But not private contract. But that is true. Absolutely true, my lord. My lord, why I am relying this decision, my lord? Since, my lord, despite, my lord, since alternative forum is there, this honorable courts can exercise their right under 226 when certain provisions is violated, my lord. Regarding fundamental rights is violated, natural justice is violated, the virus is challenged, then
you are challenging, where is the question of fundamental rights being violated? Your question, you are asking for what is that? Pay upgradation.
Pay upgradation, my lord. They have a pay upgraded me, my lord. Subsequently, after upgradation to my pay scale, they again, my lord, the earlier the pay scale.
You show us more relevant. You show us what is the second judgment.
The second judgment, my lord, L. Chandran has been discussed, my lord.
The writ appeal.
Read appeal, my lord.
Yes.
Paragraph 21 and 22.
Again, the facts, come to the
Yes,
facts.
yes. Paragraph 4, my lord. Yes, the primary contention of the writ petition reduced to its essence are as follows. Firstly, the private respondents who were recommended for nomination to IS did not hold post equivalent to deputy collector in the state civil service, as it required under Regulation 20 of the Indian Administrative Service, Regulation 97. And as such, none of them could have been recommended by the selection committee for nomination appointment to the IS cadre. Secondly, the recommendation of the DPS having been made on so the prior to declaration of the equivalent of the post of dated censure and there being no corresponding amendment to the Schedule 1 of Assam Civil Service Rules, such recommendations were invalid in the eye of law. To that extent, the notification dated 17 has also been put under challenge in the writ petition. Thirdly, the total number of vacancies being censured in the view of Rule 4, Indian Administrative Service Recruitment Rule 54, not more than 50%. The vacancies could have been reserved for the SS category officer, meaning thereby that not more than one post could have been filled up by nominating any officers from the SS category. As such, the filling of two vacancies from the officers belonging to the SCS category, respondent have acted without jurisdiction. It is also the case of writ petition that none of the officers from the SCS category recommended by the selection committee by resolution dated 20 in the rendered 8 years of service in the relevant post, which is the mandatory requirement of the rule. On such content, the petitioner have shown the interference not only with the minutes of the selection committee that is sent, but also the equivalent notification sanction. Now, paragraph 7. The respondent in the writ petition had questioned the maintainability of the writ petition by contending that, in view of the decision of the Honorable Supreme Court rendered in the L. Chandran Kumar Union of Censure, as well as the decision of this court in Tajuk Charu, but Union of India, and others reported censure, it was incumbent upon the writ petitioners to approach the Central Administrative Tribunal before approaching the High Court. As such, the writ petition was not maintainable. The learned counsel for the respondent number 8 and 9 had also questioned the local standing of the petitioners to challenge the selection and the nomination of his clients to the IS on the ground. The writ petitioner were not the aggrieved persons due to the appointment of the respondent censure to the IS cadre, hence did not have the locus the institute of the writ petition. This is the question raised regarding my lord maintainability, since Central Administrative Tribunal is the appropriate forum to challenge the issue. Ultimately decided in paragraph number findings of the court, my lord. Paragraph 22. Paragraph 22, 23, 24 discussed wholly, my lord. A careful reading of the decision of the Supreme Court rendered in the case of L. Chandra Kumar Supra would go to show that the observation made herein, the pertaining to the jurisdiction of the tribunals to act as the court of first instance with regard to the areas of law for which they have been constituted, were driven more out of concern for heavy pendency of the cases in the high courts and in view of the theory of alternative institutional mechanism as propounded by the case in SP Sampath Kumar Union of India Censure, rather to exclude the jurisdiction of the constitutional courts to entertain such disputes. It also appears from the observation made in L. Chandra Kumar's case that the Supreme Court was anxious about preserving the conferment of the powers on the tribunals, keeping in mind the unprecedented dockets exploration in the superior courts rather than to outside the jurisdiction of the High Court under Article 226, and accordingly the emphasis on the need to adopt the theory alternative institutional mechanism is highlighted by in the case of SP Sapat Treasure. In Alexander Kumar Supra, there is no finding or observation of the apex court indicating complete outside of jurisdiction of the High Court in matters where the tribunals were also empowered to entertain the dispute. On the contrary, the Supreme Court has observed that the tribunals cannot act as a substitute for the High Courts or the Supreme Court. In the case of Alexander Kumar Supra, the Supreme Court has categorically held that there was no exclusion of jurisdiction of the High Court and the Supreme Court. In Alexander Kumar undoubtedly emphasized on the need for the litigants to first approach the CAT as the court of first instance. If the dispute is one which comes within the ambit of the law for which the tribunals are created and that extent, it would be perfectly justified for the High Court to refuse to entertain such dispute in exercise of power conferred Article 226. However, such an approach of the High Court cannot be interpreted to altogether exclude the jurisdiction of the High Court to entertain the dispute. My final paragraph 24 minutes. Not entertaining a writ petition under Article 226 of the Constitution in view of availability of alternative remedy is not a rule of law, but a rule of prudence, and would depend on the facts and circumstances of its case. The ratio laid down by the decision L. Chandra Kumar Supra, therefore, must be understood to be one wherein it has been provided that under ordinary circumstances, it is the tribunal constituted under statute which will be the court of first instance to entertain the dispute falling within the area of law for which the tribunal has been constituted. The question arising in this appeal, however, would be as to whether in view of the
You
decision...
do not take this objection in your affidavit.
Not.
Why are you raising this now?
Court has, I have not, court has paused his question, Lordship, jurisdiction. Thereafter, Lordship, court has.
What is the stand of the respondents here regarding the basic pay enhancement?
Announcement, Lordship, first.
Okay, let's go. 1, 2, 3.
Lordship, can you come annexure 1, Lordship?
This is the one.
Yeah.
Paragraph 6.
Hmm?
Paragraph 6, we have stated, Lordship.
Paragraph 6.
Paragraph 6, affidavit in opposition and annexure 1, the service book we have. 51.
Fifty-one and 53 page, my lord.
What is then 51 and 53?
Yes, 51 million. My earlier basic pay, that is 11,430. It was upgraded, page 53, that is 11,850. This is the correct pay scale. Already there, in the service record. 11,850. I'm entitled this amount.
Which amount? 11,850.
1,850. Page 53.
Page 53.
Yes, my lord. It is their record, my lord.
Then?
So I'm deprived of this. Then
811,850.
yes, my lord. But they again, my lord, my basic pay after fixation of my this amount 11,850, they again fix my wrongly 11,430 rupees again, my lord. So this pay,
Yes.
it is their record, my lord. Accordingly, I retired, my lord. I raised objection. I made representation.
Page
but
57, Lordship, this is the discrepancies. As regard to the additional increment at the rate of 3%, it is stated that while CWC New Delhi later dated so and so, an additional increment at the rate of 3% may be allowed to the erstwhile matriculated D group employee, new group C.
No,
who
no,
are-
this page number 53 is a part of what?
Service book.
Service book.
Service.
So it is recorded here 1150 and 2016 to 31, 2013, 2017, granted annual increments with effect from so and so. Why is he claiming again on the ground that it has not been paid?
Lordship, kindly come to page 57, Lordship, because there was a discrepancy. Here we clarified, Lordship, why it was wrongly. As regard to the additional, there was an increment of additional 3%. It is stated that by CWC New Delhi letter dated so and so 6/8/2012, an additional increment at the rate of 3 may be allowed to the erstwhile matriculated Group D employee, Group C, now Group C it was, who were drawing less pay than their non-matriculated junior Group D employees after grant of second financial upgradation under MSCPC. The MSCP scheme was effected with effect from 1/9/2008. See, so and so.
You are raising from 57.
Lordship.
57.
Yes.
Which paragraph?
One, Lordship, referring later dated that letter, Lordship.
Yes.
Why this discrepancy occurred, Lordship?
He is not a matriculate.
No, erstwhile, but then second, further, so he was claiming the parity with some one Swadesh Ranjan Dev. That's why, Lordship, in view of the above factors, grievances was a lack of knowledge, therefore does not require any interference. It was rightly given. Further, she so and so was senior than C. He is claiming that his junior senior was given that rank that way. Due to the post of so and so grade scale of 950 to 14 equivalent to grade Group C with effect from 19 but C Manan Chandan grade petitioner here in Mochi. Grade 2 was promoted to the post of WS grade 2 in the scale of so and so.
What do you say with the judgments which are laid up by the petitioner?
That, Lordship,
because once the query is raised, you are now required to answer.
That effect, Lordship, I mentioned that Kendriya Vidyalaya Sangathan case, Lordship, the 2002 post Supreme Court 145, Lordship, I've given the copy, paragraph 19 here.
Board of Secondary.
Lordship, Kendriya Vidyalaya Sangathan and another versus Subhash Sharma, 2000, reported in 2002 4 SSC 145.
Yes.
Paragraph 19. I must say that the decision in Chandrakumar case is the product of the judicial craftsmanship and the landmark in the development of the constitutional law in our republic. Even if this judgment does not ipso facto apply to the state, here is the case of Jammu and Kashmir law, the state constitution, there is no apparent reason why the ratio of this judgment should not be applied to exercise the jurisdiction of by the J&K High Court under section 103 and 104 of the Jammu and Kashmir Constitution. The wholesome principle involved by this court is Chandrakumar could be extended to section 103, 104 as well as otherwise it would lead to an anomalous result of central government servants, employee of the central government controlled corporation, etc., working in jail being left with the option of bypassing the tribunal without falling in the line with their counterparts working elsewhere. It needs to be noticed that the employee of the Kendriya Vidyalaya were brought within the purview of the Act by virtue of notification dated so and so, issued under subsection 2 of section 14. As regard the territorial operation of the Administrative Tribunal Act, as the learned brother has pointed out, extend to the whole of India, including Jammu and Kashmir, the full bench of the High Court has also recognized the position and clarified that the tribunal will function as an additional or alternative forum without affecting the constitutional jurisdiction of the High Court. Therefore, the contention that the machinery under Administrative Tribunal Act to decide the dispute or complaints specified herein cannot be functioned within the state of does not deserve further consideration. However, it's clarified in light of the L. Chandra Kumar so the Act does not affect the affecting power of judicial review constitutional court. At the same time, the laid down in Chandra Kumar, the High Court ought not to be permitted the aggrieved person but to bypass the remedy of the moving the
We'll
administrative.
permit you to withdraw and go back to the cats.
Permission for that.
Of course, we'll
Yes,
give it.
yes.
But then counsel for the party, please. The petition is filed by the petitioner, who is well employee or good an employee of
Water resource.
Water resource.
water resources department,
Central Water Commission,
Central
Water
Water
Commission,
Government of India.
Government of India.
Petitioner served as
Work Sarkar grade 2.
Work Sarkar,
Yes, Vinod.
grade 2. According to the petitioner, he was entitled to the benefit of 6th pay commission,
Yes.
which although benefit of which although entered into his service but ultimately not granted by the respondents by placing reliance on. There is that communication. Page number 57.
57.
Communication dated 11/1/2019. So, being agreed, the petitioner is within this court. The said the matter was issued on so and so date. Subsequently, when the matter was listed before a coordinate bench, 28/8/25, the coordinate bench recorded the submission of the CGC, learned CGC, that the writ petition is not to be entertained in view of the judgment of the apex court rendered in L. Chandra Kumar versus Union of India, reported in so and so. So, is on this, it is pursuant to this that the matter has been listed before the court in a decision as to whether the writ petition will be entertained in its present form. Referring to section 14 of the Administrative Tribunals Act 1985, the jurisdiction, powers, and authorities of the Central Administrative Tribunal have been clearly demarcated under the Act, provisions of the Act, and the in terms of the say section 14, from the appointed day, all the jurisdiction, power, authority exercisable immediately to that day by all courts except the Supreme Court of India in relation to recruitment, matters concerning recruitment, so and so, except could be A, B, C, are decided to be decided by the Central Administrative Tribunal. Stop. Section 14 vests the tribunal the jurisdiction, power, and authority which was earlier exercised by the court. Counsel for the petitioner has placed reliance on the judgment of the apex court rendered in Maharashtra Chase Association, the Union of India versus Union of India, reported in 2020-13 SCC 285, and also the judgment rendered by division bench of this court in writ appeal 167 of 2018. So present these judgments in support of his contention, the learned counsel to the petitioner submits the notwithstanding provision of section 14 of the So-and-so Act. The High Court is not denuded of its powers under Article 226 to entertain such claims. So, the judgment in Maharashtra Chess Association pertained to ousting of the jurisdiction by the Bombay High Court by way of a private agreement entered between the parties, which the Supreme Court had held that jurisdiction cannot be ousted by an agreement between the private parties, by a private agreement, and also that it is a well-settled principle of contract law that parties cannot by contract exclude jurisdiction of all courts. Under such circumstances, the appeal preferred by the appellant before the High Court was allowed, setting aside the judgment of the High Court, Bombay High Court, dated so-and-so. In the division bench judgment rendered by division bench of this court, the challenge made before the court, before the single bench was a notification and the effect of and the manner in giving effect of the said notification without circulating the same in official gazette, and also the manner in which the same was given effect to without amending the Schedule 1 of the Assam Civil Services Rules 1998. So the finding of the coordinate bench that notwithstanding the provisions of Section 14 conferring jurisdiction on the CAT, where the legal issues are raised, which would undoubtedly transcend beyond the contours of the jurisdiction of the CAT, then under such circumstances, the writ court is not denuded of its power to entertain such an application. Counsel for the respondent, on the other hand, has placed into service the judgment of the apex court, Kendriya Vidyalaya Sangathal versus Subhash Sharma, reported in 2002 SCC 145. Submit that in view of section of the judgment rendered in L. Chandrakumar, read with section 14 of the CAT, that employees specifically covered under section 14 must come under the jurisdiction of the administrative tribunal, and the judgment of the Jammu Kashmir High Court declining to transfer the matter accordingly interfered with. Considering the judgments, considering the argument made, and upon perusal of the pleadings available on record and also the judgments pressed into service, it is seen that the question before this court is the grant of the benefit of
Correct fixation of pay scale.
Fixation of pay
Yes.
in terms of the sixth pay commission. So, according to the petitioner, this ought to have been given effect to by the petitioner, by the respondent authorities, as the same is already incorporated in the service book, and which ultimately came to be rejected. Communication dated so-and-so, which is impugned in the present proceedings.
11/1/2018.
11/1.
Yes.
Careful perusal, the same reveals that there is no challenge to any provisions of the act or the rules or even an obligation, that effect, it doesn't fall, the issues before the court does not require any interpretation of any law. It is a question of determining whether the claims made by the petitioner vis-a-vis the norms and the rules followed by the respondent are to be entertained, are to be allowed or not. Under such circumstances, due to specific provision in section 11 and section 14 of the Administrative Tribunals Act 1985, read with the judgment of the apex court rendered in L. Chandrakumar, the matter is delegated to the CATS,
And Milord,
Gauhati.
tribunal maybe Milord.
The tribunal is requested to proceed for hearing in the matter by giving the due benefit to the petitioner for the period which
6
the petitioner has been pursuing the remedy before this court. You'll have to file afresh.
Yes, Milord. Next month we will file, Milord, within
The
6 months. Milord.
petitioner will file the said application again afresh before the tribunal. With the above observation, the petition stands disposed of without expressing anything of the merits,
Yes.
inter se of the parties, between the parties.
And the process may be Milord, within 6 months.
I
I return 17, 19, 10.
Tribunal will proceed to hear the matter expeditiously and
Yes,
pass
Milord.
effective order as expeditiously as
March
possible.
applies. March applies.
Item 6.
Keep an item. Place
No,
the
no, no.
matter.
Well,
You don't even know what rules.
my lord, the rules
Which
are,
rules are there.
my lord, these rules explicitly says,
No. We
No,
are
this
giving
rule
enough
explicitly
intelligence.
says-
No.
no, my lord may not remove my interim order, my lord, that would affect me.
You go and file an appeal.
No, my lord may not do it, my lord.
How does
Because,
it affect you?
because-
You're in service.
yes,
It's
I'm in
question of
service.
Seniority.
My lord, I have,
When are you debiting office?
my lord,
Probably he will also be.
my lord,
complained.
my lord may see my
Don't
reply.
unnecessarily
No,
make
my
an
lord, I am,
argument
my
when
lord, it's
you're not
affecting
ready to
me.
do it.
My lord, it's affecting me, my lord.
How is it affecting you?
Because, my lord, as of today, my promotion has not been there. If he gets,
Which post are you being promoted?
my lord, DSP, Deputy
DSP.
Superintendent Police.
When is the promotion likely to take effect?
My lord, the promotion is likely to happen in the next year itself.
Next year.
Yes, because
We are putting the matter
no,
for
my lord,
hearing on
no,
July.
my lord, no, the promotion has been held up from 2022 because if this gradation list will happen, my lord, he will march over me, and that will affect the entire list.
No.
My lord, it's a simple, it's a simple.
It's simple for you.
My lord, the Supreme Court has categorically stated.
Whatever it may
My
be.
lord, the Supreme Court has categorically stated
We are
that within
not
6
hearing the
months.
matter in admission. It's coming up for final hearing.
So, my lord, then my lord, the interim order may not be
Interim
vacated.
order will be subject to outcome.
No, my
of
lord,
the
that would
petition.
affect me, my lord.
No.
No, that
Go
would
and
affect
file
me.
an appeal.
No, my lord, may not do it. My lord, that is absolute.
Don't file an appeal.
My lord may not do it. My lord, there's a direct judgment in this, my lord. There's direct judgment in this, my lord. He has, my lord, he has been sitting over. He has been enjoying his promotions, and now after in 2020,
He'll enjoy his promotion.
so my lord,
What can be
there's
done?
my lord, I'm referring to this
He is
judgment.
repeatedly saying that there is no board, my lord, but there is a affidavit filed by the
Matter will come up for
Inspector
hearing in the
My lord, my
July. Interim order passed earlier will continue this matter again for hearing
Much obliged, my lord.
in 23rd of July.
General.
Much obliged.
The interim order is continued, my lord.
It will continue till 23rd of July.
Otherwise, my lord, the right of, because my lord, in the year 2017 itself, there was a board, review board, my lord. The Inspector General of Police has filed one affidavit, your lord.
Whatever will hear you on 23rd.
But my lord, for such a long time without proceed may keep the issue subject to the outcome of the writ petition, my lord.
We have passed an interim order. Have you filed a vacating petition?
Yes, my lord, that is pending, my lord.
That will take up vacating petition. We'll take it up on 23rd July.
1626 of 2025, my lord.
We'll take it up on
My
23rd
estimation
July.
is pending, my lord.
We'll take it up on
My lord, my
23rd July.
estimation of petition may
We
be
are
pending.
continuing with the next matter. Hold on.
Much obliged, my lord.
Obliged. Yes, Mr. Das, your matter.
That is yet to.
All right, at 2 p.m. then.
the expertise departmental inquiry. Petitioner was dismissed in a expertise departmental proceeding. So I'll take your lordship through one or two facts, then I'll go straight to the what is required in an expertise proceeding. I am allowed to go through now, my lord. The 24th Supreme Court, I would like to place it. What is the meaning of expertise proceeding?
Where is the inquiry report?
I made a note, my lord. This whole thing is there. The petitions are there. I'll place the facts, my lord, to your lordship, we can see. He was appointed from the dates, lordship, we can see. 13 as a storekeeper on due selection.
Who's for the respondent?
Mr. Bora is there. He said he's coming. Then he was suspended from service, page 31. Then
Yes.
explain, your lordship, you can see the note, man. That page 32, the explanation was there. Allegations, this is a charge sheet only, mother. Allegations is there. Then thereafter, he was reinstated in supplement. We have submitted reply, page 34. Then he was reinstated in service, page 55. Your lordship may kindly see that reinstatement order, which the petitioner says he did not get it. Mr. Hemanta Sharma so-and-so, who was suspended from service on so-and-so, post is in consideration of his apology letter, and that it being the first offense in his service life. He is, however, issued this stern warning to conduct himself in a way befitting a government servant and not to indulge in insubordination. If such activity is detected, strict disciplinary action will be taken. So reinstatement order is there, but he did not get this. So therefore, another show cause notice was issued at page 59. 25/8/15, saying that he is absent from duties, etc. Page 59, I have put it in a note, my lord. All these things, it may not be relevant also for the time. Page 58, he is absent from something. He has given a reply. He said, denied delegation, please let me join. Page 60. He denied the allegation, then he said, please let me join. He was not allowed to join. Then again, a suspension order has been issued on 7/12/15 at page 63. That is in connection with some arrest, in connection with, my lord, some check bouncing case, not relating to office. Page 63. In pursuance of your arrest is in connection with, my lord, some check bouncing case. He has issued some check. No substance allowed.
Where page 63?
63. This was again his second. He was suspended, reinstated, again suspended. In connection with some person in pursuance of his arrest, and they say, we have not disclosed this before the authority. In fact, he was not allowed to join. He did not get the joining reinstatement order. So ultimately, my lord, he filed a writ petition. From the writ petition, he came to know for the purpose of his suspension allowance. And I have stated in para 11. Then thereafter, he was ex parte inquiry was done. That is at page 64. 9 charges are there. My note, my lord, I have given the charges. These are the charges. Then thereafter, he was dismissed from service at 74.
74.
Page 72. And
Then-
this inquiry report, we got it in a WPC 3194/16, which was filed for the against the order of suspension. I have stated in para 11 how I got this inquiry.
Then
Now the question is, my lord, we filed an appeal. That appeal was also dismissed.
where is this
Dismissed.
appeal?
That is at page 84.
84.
Oh, sorry, page 90.
What is the 84 is what?
84 is not entitled for subsistence allowance. That is different matter. But 90 is the order, appeal order. Okay. Page 132. We have stated in our para that never communicated the charge sheet, never communicated the inquiry, etc. regarding the inquiry. They said not all by registered post, etc. sent, but we have perused the record, my lord, on last occasion, my lord, first is to direct provide to see us the records. So accordingly, my learned friend provided me a copy of the record, which was a photostat copy. And from the photostat copy, if your lordship see the statements of the persons, the lordship will kindly see these statements are completely vague. It has not proved any documents. It has not proved anything regarding the charges. It is just a statement showing that the petitioners are absent from duties. And the charges are at page like F. May I produce the record now? From him I got it. Like on it. It's not paginated.
What is it?
This is the record, photocopy of the record.
Records of the inquiry.
Inquiry. And inquiry, my lord, if your lordship goes into, but this is not paginated, so I do not know how can I refer to this. Your lordship will get the article of charges in the record.
Huh.
I'll have to find it out.
So is it not there in the petition?
No, because it was not given to me. My whole case is not a decision expert was me.
No, your
Inquiry has been done.
purpose was never given.
No.
Then how did you find
Charge-
you
So
find the
that
reply?
inquiry report, on the basis of the inquiry report, that was also not given to me. So therefore, my lord, on this, and they say, my lord, it has been sent to
Where is your appeal petition?
appeal petition is here.
The appeal
Appeal is, my lord, no detail is there, page 90.
90. You did not raise these issues before.
No, we have said so, my lord. State pursuant to an ex parte inquiry dated so and so conducted against me without giving me the reasonable opportunity of hearing in an illegal and arbitrary. Page 91. after his reinstatement order, it was hidden, it was not sent to him, he did not get it. And when he filed an application for allowing him to join, that was not allowed. An ex parte inquiry continued. And ultimately, they can continue if they can show that actually they have sent a copy of the charge sheet to me. And this inquiry report and the documents which they relied upon for the purpose of charges, if they can show that they have done it rightly.
This
I
was
cannot say.
Mr. Bora.
Yes, my lord.
Well, may I just show one judgment? That letter, madam, it is there. P. Mark P, madam.
Yes.
Para 10, your lordship, you can receive. Note is also there. The judgment. Therefore, Rule 7 of the Rules 1999, para 10 I'm reading, which prescribes the procedure for imposing major penalty, would be applicable in the inquiry to be here. In our case, it is Rule 9 against the appellant to bring home the charges imputed to him. And paragraph 13, your lordship. The court in a catena of judgments has held that recording of evidence in a disciplinary proceeding proposing charges of a major punishment is mandatory. Reference in this regard may be held in Rup Singh case and so and so. Then paragraph 14. Rup Singh case, this court held that mere production of document is not enough. Contents of documentary evidence have to be proved by examining witnesses. Relevant extract is this. Indisputedly, a departmental proceedings is a quasi-judicial proceeding. The inquiry officer performs a quasi-judicial function. The charges leveled against the delinquent officer must be found to have been proved. The inquiry officer has a duty to arrive at a finding upon taking into consideration the materials brought on record by the parties. The purported evidence collected during the investigation by the investigating officer against all accused by itself could not be treated to be evidence in the disciplinary proceeding. No witness was examined to prove the said documents. Here, 3 witnesses have been examined, but they have not proved any of the documents. The management witnesses were merely tendered the document and did not prove the content thereof. Reliance inter alia was placed by the inquiry officer on the FIR. And paragraph, this cannot be treated as an evidence. Paragraph 15, we have noticed here in before that the only basic evidence whereupon reliance has been placed by the inquiry officer was purported confession made by the appellant for the police. According to the appellant, he was forced to sign on the said confession as he was tortured in the police station. The appellant, being an employee of the bank, the said confession should have been proved. Some evidence should have been brought on record to show that he had indulged in stealing the bank draft book. Admittedly, there was no direct evidence, even there was no indirect evidence. The tenor of the report demonstrates that the inquiry officer had made up his mind to find him guilty, as otherwise he would not have proceeded on the basis that the offence was committed in such a manner. Paragraph 15, same view was reiterated in State of Uttar Pradesh versus Suraj Kumar Sinha, wherein this court held that even in an ex parte inquiry, it is the duty of the inquiry officer to examine the evidence presented in the department to find out whether the unrebutted evidence is sufficient to hold that the charges are proved. The relevant observations are below. So accordingly, my lord, your lordship may come to page 17. Ultimately, thus, even in an ex parte inquiry, page 17, it is sine qua non to record the evidence of the witnesses for providing the charges. Having tested the facts of the case at hand on the touchstone of the Rule 99 and the law as expounded by this court in the case of so and so, we are of the firm view that the inquiry proceedings conducted against the appellant pertaining to the charges punishable with major penalty were totally vitiated and honest in the eye of law, since no oral evidence whatsoever was recorded by the department in support of the charges. As a consequence thereof, the High Court fell into grave error of law while interfering in a well-reasoned judgment rendered by the tribunal. Now, if your lordship comes to from the record, I think that inquiry, that statements of 3 persons are there. So I have seen it, my lord, nothing has been proved. And the article of charges are,
Show us the records, Mr. Bora. Where are the records?
The records I have.
Get the original records. Why are you getting photocopies? Who has given you photocopies?
The authority.
Why? Are they not aware that the records in original, is there no order? Is there an order?
order for
Records
record
of
is
the
there.
inquiry has been received. You have mentioned that. What records did you
Produced
receive?
record is there, mother. Page order dated 33/26.
8-5, we recorded your submission that you have received the records.
Yes, my lord.
What records?
This one.
These are not records. You did not say that you have received the photocopies of the records. These are not records. Why you made a wrong submission? You want an order, we'll give you an order. We want to see the records.
Yes, my lord.
Yes, Mr. Das, we'll have to see the records. Why
Yes,
should we go through
I
the
have seen, my
photocopies?
lord, from the
Yes, my lord, I will obtain the-
with the permission of the court. I find no statements proving any of the documents from any of the witnesses.
Therefore, we need the records. Heard?
Let it be
Mr.
on
B.D.
Thursday
Das, learned senior counsel, assisted by Ms. R. Deka, counsel for the petitioner, and Mr. D.P. Bora, learned standing counsel health. The writ petitioner is questioned the appeal termination order, as also the order passed by the appellate authority and the disciplinary proceeding, the inquiry report. You challenge the inquiry also.
Yes, ma'am. It was given to me in another writ petition. This is how I came to find it. Order of reinstatement was never given to us.
You have
The
given.
inquiry report, impugned order of dismissal, dated 18/12/2020, and what is 28/7/22, annexure 26.
Speaking order passed,
What is
not
that?
entered to substantial grounds.
And also the order of the appellate authority. Inter alia.
Appellate
The
authority
pleadings have been exchanged. The petitioner submits before the court that the entire inquiry was conducted ex parte and the procedure prescribed in the law has not been followed. And therefore, this is not an inquiry in the eye of law or as contemplated under 9, under the rules of the Discipline and Appeal Rules 1964. The state has filed their objections, contesting which is filed by rejected by the petitioner. It is submitted that the sufficient opportunities were granted, and the petitioner, however, failed to take the required opportunities. Therefore, there is no infirmity in the impugned order dated so and so. Therefore, does not call for any interference. But in order to decide the question as to whether the inquiry proceeded ex parte and whether the department adhered to the norms prescribed under the appeal rules, the relevant records pertaining to the departmental / disciplinary inquiry be necessary for perusal of the court. Stop. The learned standing counsel has produced photocopies of the extracts of the record. Stop. The court is of the view that the records in original be produced for perusal of the court. The next date of listing. List on Thursday is being declared as a holiday. Fourth of June.
for further hearing.
4th of June.
For
For
further
further
hearing.
hearing. 4th of June.
Okay.
My senior is on his legs in another court. Kindly pass over the matter for timely.
On the request made by the counsel for the petitioner, matter then stand down, be listed next week. Mr. P.C. Sudhia appears for the response.
In this case, the petitioner was the ex-constable of the Sasastra Sunagol,
Assam?
Sasastra Sunagol,
Oh.
and he was an ex-constable. And he was in at serving there 15 battalion at of Silang. What happened, due to unauthorized absent, he was dismissed from service. That is on 8K 2025, next at 3 page 36. And accordingly, petitioner filed statutory appeal and
The pleadings are exchanged.
Lordship.
Let the matter be listed for hearing.
This
is for admission.
Yes.
Admit.
Only
Since the pleadings are exchanged, issue would call for records, list for hearing.
My humble submission, there is a urgency from my petitioner side, because on this dismissed from service, petitioners not
This will require some examination of the records. You're challenging the dismissal.
Lordship.
You're questioning the process of inquiry. How can it be? Why should we go for admission here?
My humble submission, before the dismissal order, petitioner on due permission, lordship pass an order, second petition filed where petitioner selected and appointed in the sub inspector of Seniority. I have annexed that order in my affidavit. So where on this the dismissal from service was not joined in the next SI post. I think some the similarly situated person already joined
Who's for the respondent?
UK Gusan here.
Where is he? If you can see him, I don't see him. He said he's here.
Timing.
Not timing. Comes on some other date.
Only that he is not joined in the CRP.
But we'll have to hear your matter, isn't it? The record will be necessary to see whether how the inquiry was conducted, etc.
Well, only this dismissal order, there is no the code of inquiry was issued in petitioner and one interesting he is the only caregiver he is do mother
These are irrelevant. You are challenging the dismissal order. Let it be in July.
But short date, because said this short date, as part of May,
Last part of May. Why last part of May?
28.
28 is a holiday, declared holiday.
And then 4th of June,
All right, 4th of June.
Right.
Well,
I have telling the departmental proceeding punishment stoppage up to increment.
reading exchanged.
Lordship.
Yes. Fix it for hearing. Let it come
Lord.
in July, August. Issue good. Tell for records, list the matter for hearing
Record is here, Lordship.
in the month of August. MSN Kachari for the states S. Chauhan for the petition. Yeah. Yes.
That pertains to non-payment of family pension matter.
Hmm.
But the husband of the petitioner serving as a master rule worker matter, and he joined on service 1/4/1992, and subsequently he died on 10/11/2004. Thereafter, Malak, his post was regularized, Malak. Finally, Malak, he faced 17. Regularized by the executive engineer.
Seventeen.
17, page number 17, typed copy. Serial number 158, Madam, Viran Padgiri. Joined on 1/4/1992, Madam, and regularized, Madam, with effect from, Madam, by the order dated 18/10/2005. And that regulation order, Madam, is stated that, Madam, the husband of the petitioner expired, Madam, prior to passing of the regulation order, Madam. Yes, Madam, serving more than 12 years service, Madam, 12 years, 7 months. Right, during the course of service. Case of master role worker, Madam, past service is counted, Madam, for the purpose of pensionary benefit, Madam. And he died during the course of service, Madam. Then, Madam, rule 140 is applicable, Madam. Minimum 1 year of service. That sense, Madam, the petitioner, Madam, to be entitled, Madam, family pension. Circumstance I just submitted earlier, Madam, on, Madam, 19.
Yes, he's regularized. Why not give his pension? He expired
My lord,
before publication.
my friend complete, my lord, then I
No,
will.
no, it's completed. Do you recall?
My lord,
this?
my
This
lord.
was-
Then, my lord,
And there is an order by the coordinate bench.
my lord, exactly. That is what I am trying to distinguish throughout my affidavit submission, my lord.
Yes, please.
My lord will come to page 40, running page 40. My affidavit, my lord, para 7.
40.
My lord.
Yes.
My lord, para 7, my lord.
Yes.
I'm reading, my lord. That with regard certain measures such and such, the answering department backs state that it is true that the incumbent entered as master role worker, master role labor on 1/4/92. And his service was regularized with effect from 22/7/2005 by government regulation order dated 2005. But before publication of the government regulation order, he died in 10/11/2004. And that is true that late Biren Patgiri has rendered 12 years, 7 months and 9 days. My lord will mark this, his total length of service is 12 years, 7 months, 9 days. Whereas my lord, in coordinate bench
From
1992, total length of service. And he died prior to, my lord, the regulation order came into an
What
effect.
is the requirement for family pension?
20 years.
Family pension.
Yes, my lord. That is what my lord will come to page 33 of the writ petition, my lord. The order that my friend is relying upon, my lord.
My lord, I retired, my lord.
My lord,
The petitioner died, husband died during the course of service, my lord. Then, my lord, minimum 1 year of service is required, my lord.
as a regular employee, he was not regular, my lord. He died before regularization.
33, yes.
Now 33, my lord, para 15. That is, my lord, the honorable coordinate bench has held. My lord, taking a cue from Sanchita Roy, that is 20 years, my lord. Now, para 15. Accordingly, this code therefore directs the Secretary Government of Assam, PW Department, upon a certified copy of the instant order being served, to consider the condonation of deficiency of 1 month in the qualifying service of the husband of the petitioner who has rendered 19 years, 11 month service. My lord, here is a case where the petitioner's husband, my lord, served for 19 years, 11 months, only a deficiency of 1 month. And before that, my lord,
regularization was done. Only 1 month. Here, my lord, it is almost 8 years. So, my lord, that is the case here. My friend is relying upon this.
When was the decision taken by the government for regularization? Decision is a policy.
my lord.
When was it taken? This regularization on 22/7, sorry, regularization with effect from so and so by the order dated 3009. That is the publication.
My lord.
When-
Publication is 39/2005, my lord.
So when was the decision taken by the government?
My lord, 22/7/2005, my lord.
That
Clearly
is- that
reflected.
is-
22/7/2005. Whereas, my lord, he passed away in 10/11/2004. Prior to, my lord, that. My lord, what happens? Names were there, my lord. Government is not aware, my lord, who is still alive or not. They have sent it. But, my lord, he has passed away, my lord, long prior to the regulation order has come into effect. And, my lord, unless he has done at least, my lord, 1 year of service after regularization, that is that he was a master worker, my lord. That is the, my lord, problem. This order of the coordinate bench will not come into rescue of this petition amendment. Because there only, my lord, the court has taken, it's an equity, my lord. Only 1 month. That is what, my lord, the court has, my lord, taken into account. Only
When
one
was the policy decision taken by the government?
policy decision, my lord. That I have to, it was a cabinet decision, my lord. That I'll have to get it, man, from the department. My lord, I can understand, my lord, where my lord is
Kindly
So
looking into, my
if the
lord.
decision is taken during his lifetime, he should be given that benefit.
Well, that I have to find out, my lord. That data I don't have. I am just relying on this, what is there before your lordship. That
There is no denial that he is put in service. There is no denial that his name was considered. There is no denial, means there is no dispute that he is ultimately, had he been alive, he would have given
But
the benefit.
if you go by pension,
Only thing is that before he could be regularized, he expired.
my lord, one thing is that, my lord, after regularization, even 1 year of service is required.
Correct.
So,
We are only trying to see if there is a way to give the benefit and to the family pension.
Family pension. Only.
That to family pension.
my lord, what I can do is, my lord, I can get that instruction, my lord, regarding when the decision was taken, that cabinet decision, my lord.
Yes.
Yes, then if my lord passes some order on that, but my lord, I am tied up with this affidavit. That is my stand, my lord.
No,
Stand.
we accept your stand. Just trying to see if it's
Yes, my lord.
possible.
Yes, my lord.
It does
Throw
not have to
a
be a rule,
different prism, my lord. Yes.
because somebody who knows whose time will come when,
I understand, my
nobody
lord.
knows. But there was a collective decision to send these names for regularization. There was a decision at the government level that these employees should be regularized. The process took some time.
My lord,
Almost 8 months before he expired of that decision, it seems.
No, they only
20
prior to publication. 8 months prior to publication of that order.
publication order is, my lord, 39/2005, whereas regularization order is 22/7/2005
With effect.
with effect.
With effect. So his effect will be given from 22/7,
Yes, my lord.
subsequent to publication of the order.
kindly see, my lord,
Find out if it is possible
my
to
lord.
That part, my lord,
say that,
I can get the instruction as to whether
because this undersecretary's order is this publication of this decision is pursuant to perhaps cabinet decision.
cabinet decision, my lord. That is cabinet decision.
When was the cabinet? When the cabinet decide? Let us see. We're not made up our mind. We're just thinking aloud.
Yes, my lord. I can get it. Only I am trying to distinguish between these two orders, my lord. Why this order is not coming to the rescue of this writ petition?
You're correct there.
Affidavit is opposition filed by the respondent number 4, my lord, stating that, my lord, the matter refer to the higher authority, my lord, paragraph number 5.
Four.
Affidavit filed by the chief engineer, my lord, paragraph number 5.
That is
Higher authority for what?
To government, my lord,
For what purpose?
my lord, for regulation, my lord.
that is in 2012, my lord. We are in
That-
2026.
That happened.
but still pending, my lord.
Regularization of what?
The service of the, my lord, husband of the petitioner, my lord.
Regularization happened, my lord. Regularization happened, but he expired before that. That is the thing. Whether he will get the, my lord, the benefit of the regularization here, my
No,
lord,
no,
this
so
is
higher authority, you sent it for what purpose? Reconsider.
for reconsideration. That is in 2012, my lord.
Breakup number 5 already stated, my lord.
Is there any other judgments or authorities you'd like to rely on
My lord.
in support? There are judgments of this court. That hint we can give you. There are coordinate bench judgments of this court, which perhaps has been upheld by a division bench in matters like this.
Sanjita Roy,
Sanjita Roy,
Old judgments. Maybe late 90s or early 2000.
I will try.
Find out and come back.
My lord.
Release this matter again.
My lord will fix them after 2 weeks, my lord. I have to get the cabinet decision, my lord.
June 17th.
My lord.
At which time the council of the parties will apprise the court with respect of any such authority which they propose to rely on.
Obliged.
May be the law. But this is a case of dismissal from service. Not a petitioner, but he's a doctor by profession. My lord, he was appointed under 3F. My lord, on 28th of August 1975. That your lordship will find that annexure 1. Page number 37. The name of the petitioner is Sumara, Dr. Arun Kumar Mohanto. Been appointed under Regulation 3F. Page 37, madam.
Page number?
But the order starts at annexure 1, page 36. The relevant portion is at page 37. Top, my lord. Subject to discharge without notice and without assigning any reason, whereas Dr. Arun Kumar Mohanto MBBS is in the interest of public service appointed temporarily.
No, we don't need your appointment. What are you challenging here?
But
Dismissal order.
challenging the dismissal order.
Where is that order?
My lord, yes,
Where is it
yes,
pursuant to a department proceedings?
Yes, madam.
Where is that
Yes,
inquiry
yes,
report, show
yes,
cause?
My lord, I'm obliged.
Why are you going to your appointment
My lord,
order?
my
Is
lord,
there
my
any dispute?
My lord, my lordship may kindly come to page number 113.
113.
113. This is the dismissal order, my lord. Lordship will find the relevant
Where is the show cause?
My show cause is at page number 81. My show cause was done on 1997. And departmental inquiry started after serving me the SARS memo on 2018 after my retirement. And dismissal has
After
been,
your retirement?
my lord.
After your retirement?
Yes, my lord. And that, oh my lord, that also, my lord, the dismissal order has been given effect from the date of my absence, giving a retrospective effect, my lord. Lordship may kindly come to the dismissal order, my lord.
Page number 114. May I read the last paragraph?
Yes.
Now, therefore, the government of Assam in Health and Family Welfare Department hereby imposes the penalty of dismissal from service, which shall ordinarily be disqualification for future employment upon Dr. Arun Kumar Mohanto, the then Associate Professor of Dermatology, Silchar Medical College, as per Rule 7, Chapter 7 of the Assam Service Discipline April 2, 1964, with effect from the date of his absence from government service, that is 8/8/1994. And this order was passed on 20 March 2019.
Do appeal file?
Appeal was filed, madam. Appeal was filed, appeal was dismissed, madam. Lordship will find the appeal at page 134. This appeal was filed under order passed by this honorable court, madam. Filed the appeal before the appeal authority.
What is this writ petition that you filed?
I have held the dismissal order.
Then?
Dismissal order and the order filed by the appellate authority.
In page number 120, 121, 123.
Yes, madam.
What did you challenge?
Here I challenge the dismissal order.
Dismissal.
Then the honorable court directed me to file an appeal.
Appeal.
Thereafter, I filed an appeal. Your lordship will find the appeal at page 134. Here, in the subject, I have mentioned an appeal filed under so and so. As per order date so and so, passing WBC number so and so. So after filing this appeal, the appellate authority had passed the order, speaking order at page 152. The operative portion is at page number 156, last paragraph.
But this is something to do with voluntary retirement.
And I applied for voluntary repayment. That was not.
After you approached this court, there was a direction to file an appeal.
Yes, ma'am.
Appeal against what?
Appeal against the dismissal order.
Dismissal order. Yes, so why did you file the appeal against the appeal seeking voluntary retirement?
My initial
152 is what?
Yes, ma'am.
What is 152?
At 152 is the order passed in the appeal by the appellate authority.
Appeal seeking what?
Appeal seeking to recall the dismissal order.
Dismissal order. Then come to page number 156.
Yes, madam.
It has rejected your prayer for voluntary retirement.
Yes, madam. At that point of time, madam.
Huh?
At that point of time, madam, I applied for VRS. That was not accepted by the authority. Actually, madam, there are two prayers, madam. Either you allow me to go on VRS, or pay my pension benefits. The SOPOS was issued in 1997 and the departmental proceeding started in 2018 after my retirement. And that they have passed the dismissal order with effect from the date of my absence in 1994. And even in the second SOPO notice, they have mentioned that we are going to dismiss you. This order has been passed only to deprive my pensionary benefits and other benefits, my lord. I was neither suspended nor terminated during that period, my lord. I approached this honorable court, including my grievances, my lord. Thereafter, the department came in action, my lord. Started all this departmental proceedings against me.
Yes.
Lordship. Lordship, I have filed my affidavit, Lordship. Lordship, may kindly come to para number 11, Lordship, at page 161. Lordship. May I read, Lordship?
Please. Yes, please.
That with regard to the statements made in paragraph 9 of the petition, the deponent begs to state that the case of the petitioner was disposed of by issuing a speaking order by order dated 9/1/23 and was decided that upon careful perusal of the order passed by the Honorable High Court in WBC number 4930/18 dated 21/3/22 and also taking into account the written statement of the petitioner submitted on the day of hearing, that is on 13/12/22, careful scrutiny of the available office records and specific views put forwarded by different departments and also APSC, the Medical Education and Research.
This is an order passed by whom? Which order are you reading?
It is a speaking order,
Passed by which authority?
the Medical Education and Research Department. Also.
The what provision? Why have they passed this order?
He was seeking voluntary retirement. Lordship.
Voluntary. Yeah.
That is the last paragraph of the speaking order. And
No, this is a part of the appeal.
yes, Lordship. Hereby rejects the prayer of Dr. Arun Kumar Mohandas seeking voluntary retirement from service as he is not entitled to get voluntary retirement as per existing notification and guidelines of the government, and also rejects the appeal petition for revoking, modifying the order of dismissal issued as per provision of the Assam Services Discipline and Appeal Rules 1964. However, the department
So this is a common order rejecting his prayer for
Yes.
voluntary retirement as also his appeal.
yes, Lordship.
Now, under the
And
rules, how is the appeal to be decided? Is there any provision,
and
any guidelines?
another Lordship, may kindly come to my affidavit, page number 174, Lordship. Last paragraph, Lordship. Whereas the Honorable Court in its order dated 27/7/18 in WBC number 4930/18 directed the following. Till the next returnable date, the impugned letter dated 21/6/18 issued by the Joint Secretary to the Government of Assam remains stayed. Whereas the page number 173, last portion. Whereas unauthorized absence is a serious offense and gross negligence on the part of a government servant was unauthorized absent from his duties for a period almost 2 decades. Whereas Fundamental Rule 18 stipulates that after 5 years continuous absence from duty elsewhere, then on foreign service in India, whether with or without leave, a government servant shall be removed from service. That's so, Lordship, his prayer for seeking voluntary retirement was
Rejected.
and also dismissal is dismissed from service.
But if you look into your rules, there is a manual of departmental proceedings.
Sorry.
If you have that manual, if you can come to page number 520, 8.6.6. There the guidelines lay down how the appeals in respect of imposition of penalties are to be dealt with. Yeah. Eight point 6.6, subclause 2.
Subclause 2, posing penalties. that authority will examine the facts and arguments contained in the appeal with reference to the records of the order appealed against and the appeal. Yes, Lordship. Also examine whether the procedure prescribed for holding the inquiry and for imposing on the penalty is prescribed.
So what the appellate authority is required to examine and what it will consider.
After going through the appeal, the authority has decided this.
Correct, but is there is no reference. What evidence was discussed with? How the evidence was appreciated, whether the procedure was followed with? Nothing. They clubbed up two issues. One is you reject the voluntary and then you reject the appeal. All right, voluntary is not challenging. Rejection of the appeal, you'll have to follow the procedure or not. There is in fact no finding as to why the appeal is rejected. There is no finding on merits. Mr. Monto, therefore the APSC. Any consultation required?
Consultation just for approval. Whether we just APSC looking to whether the procedure has followed or not. That is all. Very
Have you given any opinion that procedure followed, etc., not followed?
order, there is a line I have seen. There is a approval from the APSC.
Approval pursuant to the order passed.
It is not 54 and 3 matter.
You address the court, madam, whether this procedure is to be adhered to or not by the department.
As required by the law.
This manual. Because if the manual is to be followed, then the order of the appellate authority has not discussed anything. Unless you say the manual is directory, non-mandatory for the authority.
We will obtain some instructions of setting procedure. So ultimately it's a matter another day.
Yes, Mr. Das.
And as per the special order, if your lordship kindly pay us case number 114, the last paragraph, my lord, which I have already shown to the lordship, the dismissal has been given effect from the date of absence. This order was passed on 20 March 2019.
We are not going into the merits as yet. You have filed an appeal, your appeal has been rejected. Now, whether in terms of this, the appellate authority is required to decide the merit, decide the appeal in terms of this, or is it not mandatory? What is your submission?
My submission is that they have to follow the manual. And
why do you submit?
Otherwise, what does the rule says? Rule has to be followed.
So
that is just a guidance.
Show us that the rule has not been followed by the appellate authority.
Yes, madam. So that I'm showing, my dear lordship.
By the appellate authority.
Yes, madam. But they have discussed nothing. Lordship may kindly come to again.
Which rule says they'll have to discuss and to what extent?
But as per the Assam Service Disciplinary Rule, my lord, the appeal has been filed. And the so-called notice. Lordship may kindly come to the so-called notice first, my lord. So-called notice is at page number 81. Now, the so-called notice says that there is an unauthorized absence. So-called notice says, my lord, which was served to me in 1997.
And I replied to this, my lord. If your lordship kindly. Lordship, come to page 54, my lord. My answer to this so-called notice. I said that my wife is under treatment of cancer, so I need my leave. Otherwise, my lord, I had also in here, my lord, in my letter dated 27 to 1998, I said that if my leaves are not granted, so kindly let me go on PRS. At that time, I was eligible, my lord. But they said that no, there are,
You said the procedure is not follow. Which procedure? In what manner?
my lord, they manner at that time coming, my lord. The so-called notice was served to me in the year, my lord, 1997, and SARS was framed on 2018, my lord. This is number one, my lord. Second is, my lord.
No, number one means what?
It's not out.
To say that it is contrary to the rules.
Contrary to the laws which have been set up by this honorable court and honorable Supreme Court, my lord.
Show us where
Yes,
have
sir.
you placed these?
Yeah. Lordship may kindly come to the first decision, madam.
If you, the subject to correction, I don't know, Mr. Monroe, I think the judgments are required to be shared with the council, isn't it?
Yes, I'll share, madam. I definitely
Before you address,
I'll share, madam.
isn't that the practice? Wasn't
I'll
that the
share, I'll
practice?
share. I'll share.
Nowadays, madam, giving a copy of.
What is the fun in
Madam,
giving it close to your heart?
I'll share.
You should share that these are the list of
Yes.
books. At least the court master.
Earlier, we are giving the list of books in advance.
So why have you given us?
Nowadays, my lord, we are giving a printed copy, my lord. That's why, at the time of hearing, but at the moment.
So why have you given up that golden practice?
Well, we'll follow, madam. We'll follow.
Normally, when a book job is.
So we are asking you why have you given up? I'm not saying you
I'll
follow.
start there also, madam.
So serve it, then we'll hear you. Serve it. It helps the court also to go through the judgments.
Now everything is kept within the content the para also. But it is not necessary to go to entire judgment. Now my everything on my lord.
Yes, sir.
Pinpoint the answer the para.
In the first judgment, madam, there different lordships comes to case 116. The judgment, 2014 12 SCC. But there is, here, madam, three numbers of issues were framed. Number one is whether the employee then could have in law pass an order of dismissal with retrospective effect. But this answer your lordship will find the next page, madam, that dismissal from service with giving the retrospective effect is not permissible, madam.
Where?
On the next page, madam. Para 15, madam.
Next page, para number?
Para 15, madam. Which starts as A, B, and C. Small c, madam. This court opined that the order of dismissal with retrospective effect is in substances and an order of dismissal from date the order with the superintendent direction that the order should be appointed retrospectively as from an interior date. So, madam, this is the first case, madam. Where it says, madam, that the retrospective madam, dismissal is bad in law, madam.
Where does it say? This is the contention. The contention of the council is discussed. Here is the finding.
Lordship will also getting paragraph number 41, madam. Is 130. Last paragraph, madam. Paragraph number 41.
Have you read this judgment?
Yes, my lord.
You have. Then tell us what is the facts.
That is about he was a bank employee, my lord. His dismissal was done. That was that was interfered, my lord. But here in paragraph number 41, it says, my lord, we have already held that the said order would not have been made retrospectively operative, but that will not invalidate the order of dismissal, but it would only have prospective effect as has been held.
Where? Where is it held?
But held it, my lord, this are
Yeah?
are referendum.
Where is the judgment?
But that is not AIA 1966. Just see.
Not available.
Just made a mention of this. What you could also get the paragraph 45, paragraph number 45. Yes. Yes, my lord. The next law is, my lord.
Not like this. We'll continue for hearing. You're not prepared to take us to the point. We asked you a question, there was no response from you. That will be listed for hearing again on fourth. Is it for hearing or admission?
Admission.
It's admission.
Admission. Better be listed for hearing. All for the reports.
Rule have been issued earlier, madam.
Then how is it for admission?
In the past that.
Notice was issued.
The person required on 2012, madam.
Therefore, you prepare and address the court. We are willing to hear you. You are not able to answer the queries of the court. What to do?
His another prayer was GIS money and.
So that is released, we have seen.
Well, nothing has been paid, madam. Only documentation has been done, madam.
Are you now pressing the GIS or you are questioning the interference of the
Interference, madam.
interference?
Dismissal order.
So therefore, you address the queries that we have put.
Yes, madam.
We'll continue on 4th of June, list on 4th.
Lots of keep it as a part of, madam.
Why? We are trying to hear, you are not assisting. What to do? How can it be parted? It will be parted only when we hear it. You have not pressed the argument. You don't have the judgment which is referred to.
I'll try again, madam.
Try again. on
আমার
fourth.
আমার today
Not today. Fourth. Yes.
What should be the original record I've given the translated copy?
Oh.
The statement of the petitioner. If I have made inquiry from the registrar, he was not allowed to cross-examine the witness. No opportunity was given.
Was he present?
No,
No,
no, you know.
He's not even present.
Not even
on that day he was not there.
No, not on that day, on any day.
Yes, it was there, Lordship.
Only one day I was called.
Lordship, there is a limit to submission, Lordship.
No.
Lordship may please to see the record whether he was
Yes.
present on.
On 2 occasions.
Yes, on that day he was
Given
not
the
there.
Dates also.
I'm admitting, Lordship. Lordship, his statement may be seen, page 118.
Who is for the private respondent here? There.
No, there's no private respondent in mine.
No,
In
no,
my
the
case.
complainant or something.
Yes,
Even
yes.
IA, they have filed to implead themselves in this application. These are the two complainant girls, Your Lordship, allegedly.
Implement. Why do you want to implead yourself?
That's they're the complainants.
But according to the inquiry was conducted, but there are some issues with regard to procedure. Then
Lordship, as we have come to know that the petitioner has filed the writ petition, Lordship, before this honorable court, that being the complaint, that if any adverse order passed or for assisting the court, if possible,
you're representing both
Lordship,
both the complainants.
Lordship.
But if the procedure is not followed, then the delinquent employee has to be given an opportunity.
Lordship.
As per the procedure. What do you say?
Lordship, as the rule describes, Lordship, if any rule was not properly followed, then we have nothing to say, Lordship. It is up to this honorable court. But being the complainants, Lordship, wanted to implement, yes, only this much, Lordship. And only the opportunity of hearing us.
So we will permit you to be
Lordship.
impleaded, provided you say that the claims made by the petitioner for some reason or the other is not supported by the records. Is there anything there you want to submit?
Lordship, if we are implemented, Lordship, then we can file affidavit, Lordship.
And this page.
How soon can you file your affidavit?
Lordship, within 4 weeks.
4 weeks is.
What
Two,
is if I may
three.
just pray, Your Lordship, I filed my objection against an affidavit in opposition against the impleadment, Your Lordship, against the prayer for impleadment. In service rule, Your Lordship, where is the question of having them as a? This is a completely the grievance of the applicant is not against them. The grievance of the applicant is against the authorities and how in the manner in which they have conducted the disciplinary proceeding. Where is the question of having the complainants within this particular in service jurisprudence?
Your very ground is that the complaints are baseless.
Yes, Your Lordship. Does my claim say that the complaints are baseless? Who is the authority to decide that? Either the disciplinary authority or Your Lordships. What can the complainants achieve by getting impleaded in this particular petition? They have already filed criminal cases against me. I am facing 2 trials, Your Lordships. Where is the question of impleading themselves in a service proceeding, Your Lordships? That is my respectful submission before Your Lordship. The only thing it will achieve is just prolonging my suffering I have been without a job since 31st of October 2025, Your Lordships. They have filed a complaint against me in the Assam Women's Commission, before the National Women's Commission, before the Deputy Commissioner, before the ICC, before the trial court. They have filed FIRs against me. Forum fishing everywhere, Your Lordships. Without, and Your Lordships, if you're naturally, it is not within your Lordship's domain.
The whole proceedings against you arises from the complaints initiated.
Lordships, and till date, I do not even know whether my learned friend says that there are 2 complaints. My learned friend also says that there are 2 complaints. To my knowledge, when I asked them, when I was sitting before the ICC, I was told that the complaint is only with regard to Ms. Hema Biswakarma, not Ms. Priya Singh. It is now that the records, my learned friend has produced the translations, that I am finding that is also a complaint by Ms. Priya Singh. And although the annexure 4 of the memorandum of charges talked about it, nothing was ever given to me. Whenever I asked them to give me a copy of the complaint, they have not even provided that. My learned friend was just relying upon page 118 of the records, Your Lordship, wherein this is my statement made before the authority on the second date that I was present. I appeared before the ICC only on 2 dates, Your Lordships. One is 6/3/2025 and one is 24/7/2025. What dates they had called me. And in this 118 reply also, I can show to Your Lordships immediately that I have asked for the documents at Annexure 4. I have said that I request you to kindly give me a defense assistant. Nothing has been done about it. They have appointed a presenting officer, and they've given me 3 days time to find my defense assistant. Now, naturally, there's a complaint of sexual harassment against me. I've become a persona non grata in the university. No one even is willing to touch me. Where am I supposed to find a defense counsel from? I tried different organizations also. I tried to find a government servant from different organizations. No one was willing to come forward. They did not allow me that also. That is my statement made before the ICC. What my learned friend was just trying to produce. My senior counsel, Mr. Kyal, was just producing this. Lapses at every stage, a lot. Where am I supposed to go? The inquiry report never submitted to me. Admittedly, Mr. Kyal is himself saying, the learned senior counsel is himself saying that I was not allowed to cross-examine the witnesses. The memorandum of charges talks about 2 witnesses, Your Lordships, Hema Biswakarma and Priya Singh. That's it. I do not know how the others have come in, from where they have called these people. Memorandum of charges covered page number.
Yes, Mr. Kaya.
If I will just point out page 61 of the petition, you'll also find the list of witnesses as per the ICC report. Page 61 of the petition. This is the last page of the memorandum of charges which was issued. List of witnesses, you'll also find in the center of the page. What are the list of witnesses? Ms. Priya Singh, student of so-and-so, Ms. Hema Biswakarma, research scholar of so. These are the 2 witnesses, supposedly. Now they have gone ahead and examined 10 other people. I do not know who these people are, without even providing me a list of the people who have been called as witnesses.
Yes.
I think that regarding the procedural, I've already admitted that some procedural defect is there. Lordship, after CL judgment, it may allow us to continue from the defect Lordship on.
Yes, Mr. Sarkar. No, hearing for what purposes? We are asking you that there is a procedural lapse. You show us, prima facie, you show us that notwithstanding these lapses, matter doesn't require reconsideration. Show us. No filing. You show us prima facie, then we'll permit you to file if required. You show us from any judgment, any authority, that if the procedure is not followed, notwithstanding that, in matters of this nature, it's not necessary to, or he does not face any prejudice. Sure. That we have heard. Anything to submit on this judgment? Krishna Dutt Avasthi. What is the judgment? Hmm? Hmm?
Joining as a party. Yes.
But this is this only says that the matter is referred to a larger bench. No, this judgment that you're placing, Krishna, that is by you. It begins by saying that there are divergent views, so the matter is set to the Chief Justice for constitution of a larger bench. Right? Huh? Huh?
Can I get that?
That is precisely my case, Lordships. I'm grateful to my learned friend.
Should be included only this month. Regarding
You'll file reply to what spec? That's what we're asking you.
Otherwise,
That requirement is not from us, it is from you. You tell us for what purpose.
for any that we have done.
You file it let them file it within 2 weeks. We are overriding your objections, let them be impeded. Let them file their objections within 2 weeks.
Lordships, what can I say, Lordship? The fact remains that they have also filed so many cases. I'm facing a criminal trial against their proceedings. They have had a chance to say whatever they want to over there. What is it that they're going to file, Lordship? The fact that they recorded the ICC, the fact that they recorded ICC proceedings.
That since they are the complainants and they have sought for a audience from the court, let them be arraigned as a party. They have any reply to file, let them file. Let us consider the matter. What is there to shy away from?
Nothing to shy away, Lordship. The records are already before your Lordship. There's nothing to shy away from,
That's
your
right.
Lordship.
Had they not come
And
before the
the
court by
procedural
filing
lapses,
an
my
application,
learned senior counsel has himself accepted about the procedural lapses. What else remains in the matter
that's
thereafter?
the more reason why we want to hear them,
Lordships.
because they are the complainants.
They have filed the IA 3 months back, Lordships.
Yes.
Lordships, another 2 weeks, I'm left hanging, Lordships.
You have come to the court what to.
Yes, Lordships.
In the IA, you write heard counsel for parties. The IA has been filed by so and so. Don't give the names by the applicants who are the complainants in the complaint filed under the Post Act against the writ petitioner, on which the authorities have filed have passed a order. What is that? Removing.
Yes,
Removing
compulsory retirement. Compulsory retirement.
imposing compulsory retirement. While the application is being posed by the petitioner, on the ground that they are not necessary parties, the fact remains that they are the complainants, basis of which the complaints, the basis of which the ICC proceeded in the matter and had rendered the impugned order. So, this court is of the view that considering the issues involved, the matter, although considering the issues involved in the matter, the court is of the view that the applicants who are complainants be also added as a party, giving them an opportunity to file their objection, their affidavits, if any. So I accordingly stands allowed. The petitioner will file amended course title within 3 working days before the registry, and we'll also serve copies of Mr. S.K. Sarkar, who's representing the complainants and as the applicants. Complainants are arrayed as respondents number 6 and 7.
6 and 7.
So the complainants are permitted 2 weeks time to file their affidavits / objections, if any, in the matter. List again after 2 weeks.
Kindly give me
And Mr. S.C.K.L. appears the university,
Assignments.
Assam University, Ms. Pooja Agarwal from GC. Is these matters on
16 junior subject to
16 June?
16.
But
But just perhaps they could serve it on us a little earlier ahead so that we can also prepare our, if in case a rejoinder is required.
The applicants, if they propose to file any affidavit, should have the copies served on the respective council by 12th June.
Just a little earlier by 10th of June so that we can bring it on record as well for your lordships.
It is for them to bring it on record.
Your lordships, I'll file it by 12 and then at least it will come in record by
10th
10th of June.
10th of June.
Deeply obliged, lordships.
This matters according.
Lordships, may I make one small?
The records presented before the court are returned back to Mr. KM.
Lordships, could I perhaps make one prayer subject to what my learned friend says? Because of the fact that the trial continues against me and lots of witnesses have made statements in my favor in the ICC, to my knowledge, whatever has come from the affidavit. Could I perhaps be given some copies of that so that I could produce that as my defense over there in the criminal trial?
That
If I make an application to the university,
your prayer on 16th.
Lordships, the trial is already there are 2 more dates in between 16 also.
Trial before the
District and session judge, one trial.
you file applications there.
Lordships,
Then
they
the
don't provide me
appropriate-
copies.
Huh?
Lordships, I've tried asking them n number of times. So perhaps a direction, just that if in case I make an application, at least the copy should be provided to me. That just that much.
Not like this. You file applications, there are forums, you'll have to go through it. If they're refusing to.
Lordship, that is why I'm before your lordships, because I have tried
No, you
all
are
forums and
question-
they're not giving me anything.
Questioning the proceedings
Yes, sure.
primarily.
That is what I'm asking for, that the copy of the proceedings should be given to me.
Ah.
That the inquiry
That will
report is
decide
one
on
of the 2 of the statements of
That will
the,
decide on 16th, therefore the matter is fixed at your request. On
not my
16th.
request, your lordship, at his request.
And with the affidavit
I would have
section,
wanted
we
the matter to
annex
get
all
over
that
today, your
documents.
lordships.
With our affidavit, we have annexed all that document. Inquiry report and all.
They're not.
You renew your prayer, we're leaving it. We're not
Okay.
saying anything. If it is required any further document, you renew it on 16th.
Not for the purpose of this particular case. Lordship. The fact remains that those could be my defenses in my criminal trial.
That we can't
And they
say.
refuse to give me any copy, your lordship. That is the difficulty.
Can't say, not say that.
Lordship. Deeply obliged.
Yes.
Case one of the petitioners would also be eligible in the year 2024. It
DPC not consider the anticipated vacancies for which they were left out. 2025, again the DPC was held. The petitioners were put in the zone of consideration. This time also, DPC, considered only in respect of the junior cadres, but the petitioners cadre, they did not consider the cases because they wanted amendment of the rule. In fact, in respect of the junior cadres also, the rule was amended subsequently in the year 2026. That minutes of the DPC is under also challenge, because the DPC, the duty of the DPC is to make the recommendation for promotion. They cannot, of their own, they can recommend the government for amendment of the rule. Have you give us a list of the judgment? Don't give us printouts. Why give us printouts? We are not used to legal. We take printouts, but give us the citations. Fine. It's nice of you. We are happy that you have taken the trouble to give us printouts, but we don't need printouts. We take printouts, but just give us the list. Name of the citation, name of the party, paragraph numbers. If maybe half a line, for what purposes we were relying on this. This is what we want. 1 page, 2 pages. No, we are not adjourning the matter on that. We are just trying to understand, because your case is that prior to the amendment of the rules, there were vacancies available which were not taken into consideration. Had they been taken into consideration, you would have been promoted. Right? Right. And the rule says that, every year they have to make the commence the selection, and they have to assess the anticipated vacancies also during that year. But the DPC will not consider the anticipated vacancies. In the rule, you will also takes up the rule at page 33. Well, at page 38, Which writ petition? WPC 2421, Yes. Where is the rule? Rule starts from page 33, and regarding the anticipated vacancy, relevant rule is rule 12, page 38. Rule 12 says, before the end of each year, the appointing authority shall make an assessment of likely number of vacancies to be filled up by promotion in the next year in each cadre. So, along with the existing vacancy, the DPC has to consider the anticipated vacancies also, which were likely to fall in vacant within the year. This is page 36. Page 38. Rule 12. The end of each year, the appointing authority shall make an assessment of the likely number of vacancies to be filled up by promotion in the next year in each cadre. Well, 4, selection shall be made on the basis of seniority come. And how is the selection made?
Selection was made on the basis of seniority company. I have no grievance against the malad persons promoted. They were senior to us, though they were batchmates, malad. They were senior to us. But our case is that malad, there were vacancies. We are working on in charge basis. Despite that, malad, our cases was not considered for promotion. They are extracting the service from us.
But if the department has taken a decision, it requires some changes.
And it is not a decision of the department, my lord. It is the DPC, my lord, who has recommended, my lord, for
DPC has
amendment of the rule.
recommended, DPC has recommended, but the matter, some level was decided. Or maybe DPC was of the view that some changes are necessary. Meaning thereby that at some level, whether at the DPC or at the level of the government or the level of the appointing authority, there was a decision that this particular qualification needs to be altered.
Only the experience part, my lord, they have, my lord,
Whatever
earlier it was
experience,
for,
and there's a degree also, I think.
no, man.
Graduate or something.
Degree has not been my lord, changed.
Experience.
Only the experience part, earlier it was or, now it has been made and. Earlier it was, my lord, 5 years or continuous 12 years of service in any cadre. Now it has been made, my lord, 5
Now,
years.
because of the changes, what is your, how are you placed? Because after the amendment.
Now we have not completed the 5 years of service in the earlier cadre, my lord, present cadre, my lord. That is why, my lord, our cases are not considered. But the persons who have already been promoted, our bestmates, they have been promoted on completion of 1 year, my lord, in the present cadre.
Further promotion.
My lord. Our bestmates have been promoted.
The next higher post.
My lord.
What is that post?
My lord, in this case, my lord, the district level, my lord, district fishery development officer, my lord. In this case, in the other case, my lord, this deputy director. And only because of the DPC was held, my lord, for consideration of promotion for three categories of post, my lord, 3 cadres. But my lord, only these 2 cadres were left out because they opposed the dishonorable code. The other cadre who did not oppose the dishonorable code, my lord, they have been recommended, they have been promoted. I have collected some decisions, my lord, wherein it has been held by the EXCO that consideration should be made in time. It cannot be delayed. Rule says that, my lord, the anticipated vacancies should be counted. So if the anticipated vacancies is counted, our cases should be considered with effect from the dates when our bestmates were promoted. Even if, my lord, the anticipated vacancies are not counted, in the second DPC, that our cases should have been considered. To deprive us from the benefit of promotion, my lord, the rule has been amended by the authority now. The rule they have implemented this rule.
That is an allegation. That is an allegation based on malice.
My lord,
That you are being deprived of somebody wanting to be deprived.
Had there been no promotion on the basis of the rule, earlier rule, it should have been, my lord, presumed that the rule was something was in fault, my lord. So, my lord, there no consideration was made on the basis of
Is
the
it your argument that the authorities are deliberately depriving you by amending the rules because they don't want you to be promoted? Or is it a case that you had an actual right to be considered that was overlooked by the department by bringing in the amendment and not considering it? Which one?
My lord, the second one.
Why are you making the argument, sir, that they deprived you deliberately?
What
comes from the record number. The rule has already been implemented. The rule which they have recommended for amendment, the same DPC has already recommended our best match for promotion on the basis of the same.
Understood there, but there was a decision taken. That is not under challenge.
Or the minutes of the DPC is under challenge.
Not minutes. The amendment of the rules. Is it under challenge?
No. The rule is, we have filed a petition in the year 2025,
Prior to amendment.
Rule was amended in the year 2026, Just my petition was filed on 30.
Which judgment you are relying on for the proposition that your consideration should be made within time?
My lord, that is the first judgment, my lord, 2010 SC, my lord, 1682.
What is the name?
Union of India and others.
Emirates.
My lord, Emirates. Paragraph 37. My lord, in the paragraph numbers on the top, my lord. Court must keep in mind the constitutional obligation of both the appellant, the central government, as well as the state government. Both the central government and the state government are to act as model employer, which is consistent with their rule in a welfare state.
Paragraph?
Paragraph 37.
Yes.
Paragraph 38, my lord, it is an accepted legal position that the right of eligible employees to be considered for promotion is virtually a part of their fundamental right guaranteed under Article 16 of the Constitution. The guarantee of a fair consideration in matter of promotion under Article 16 virtually flows from the guarantee of equality under Article 14 of the Constitution. The manager, government, branch, press, and another versus DB Baliappa, reported in so and so. A three-judge bench of this court in relation to service dispute, maybe in a different context, held that essence of guarantee epitomized under Article 14 and 16 is fairness founded on region. It is therefore clear that legitimate expectation of the respondents of being considered for promotion has been defeated by the acts of the government, and if not, the central government, certainly the unreasonable inaction on part of the government of UP stood in the way of the respondents' chances of promotion from being fairly considered when it is due for such consideration, and delay has made them eligible for such consideration. Now the question is, which is weighing on the conscience of this court, is how to fairly resolve this controversy. Next paragraph is paragraph 45. The facts of this case, neither the appellants nor the state of UP has justified in its action of not undertaking the exercise in the statutory time frame on any acceptable ground. Therefore, the delayed exercise cannot be justified within the meaning of ordinarily in the facts of this case. In fact, in the facts of the case, therefore, the court holds that there is failure on part of the authorities in carrying out timely exercise of cadre review. Next paragraph, 47. It was urged before this court that the insertion of the word ordinarily will make a difference. Repealing the said contention, this court held that the word ordinarily does not alter underlying intention of the provision. This court made it clear that unless there is a very good reason for not doing so, the selection committee shall meet every year for making the selection. In doing so,
the court rely on its previous decision in so and so versus so and so. In that case, the court was considering Regulation 5 of Indian Police Service, the Regulation 1955, which also contained the word ordinarily. The context of the word ordinarily has been constituted as since the preparation of select list is the foundation for promotion and its omission hinges upon the legitimate expectation of promoting officers for consideration of their claim for promotion as IPS officer. The preparation of the select list must be constituted to be mandatory. The committee should therefore meet every year and prepare select list and be reviewed and revised from time to time as exigencies demand. Paragraph 49. Therefore, this court accepts the argument of the learned counsel for the appellants that court cannot be constituted to have any retrospective operation and it will operate prospectively. But in the facts and circumstances of the case, the court can especially having regard.
What do you say, Mr. Sir? Sorry, we'll come back to.
Regarding this judgment, I have not gone through it. Regarding other part of
The
it.
rule says that every year you should make an assessment and then
Yes,
select.
yes, I'm just going to read. Yes, rule says before the end of each year, appointing authorities shall make an assessment of likely number of vacancies to be filled by the promotion in the next year in each cadre. It is true. But while selecting while this earlier service rule, your lordship, that while selecting that rule was not followed. That is admittedly not followed. As per my records.
If it is not followed, then they have a right to be considered. Whether they are promoted or not is a different issue. But the right for consideration has been taken away.
The right for in
Then
my
what is the
as
reason?
per records given by here lordship, I have given lordship on the other days of lordship. I don't know whether this is when the in earlier part when the rule was not amended on that occasion lordship they have stated that there are only 10 vacancies. Only 10 vacancies. When 10 vacancies all are being appointed, one is being kept vacant because of PWD and this all this part. Three are being vacant. No vacancies are there.
How many persons were promoted?
Only 7.
7.
10 were vacant.
There were 10.
10 or 3 were there is lordship
PWD.
ST Hills and SC and PWD. No, there were no.
So there are no candidates.
So this one not filled.
Now, so far as the petitioner's claim is for which vacancies?
Yes, vacant.
Anticipated. These 3 vacancies.
See, they were saying that there are vacancies. They were anticipating that there were vacancies. Here, we're going to the records, which I produced on the last day also. While considering the batsman in earlier service to lordship, the first part was only one. So the first page lordship there is saying that the 10 vacancies.
No, beyond these 7 and 10 vacancies,
Not
are there any other vacancies available, anticipated?
No,
Yes,
at that moment, no vacancy.
Immediately after promotion was made, the same month, we have proposed another 10, 8 posts for filling up vacant post, existing vacant post for filling up. At page is 53. Page 53. Page 51 is the promotion order of my best mates. 9th October 2024. 9th October. Then 29th October 2024. The same month. They have said another 8 numbers of
Year-wise vacancy. 4 numbers.
7 numbers. 56. 56.
53.
7 members, another 7.
No, then what is 54 and 55?
This is different cadre, my lord. 56 is the, my lord, vacancy position,
DFDO.
DFDO, District Fishery Development Officer. The same month, my lord, they have sent another 7 posts.
What happened to this?
These posts were considered in the 2025, my lord, DPC,
After amendment,
prior to amendment.
prior to amendment.
This was sent for, my lord, filling up in the DPC held on 2024, 25. That DPC, my lord, did not fill up this post.
They recommended for
For
amendment.
amendment, yes, that's
So this post should have been considered in the first DPC in terms of the movement.
All right. There were vacancies. Mr. Sharma.
yes. As per yes, yes, that is,
The cases ought to have been considered.
there were vacancies.
How many writ petitioners?
My lord, in this case,
But here now, Lordship, they have not said, my stated submission is that they have
Five
not challenged the rules.
5 writ petition.
In both the writ petitions.
No, in this cadre, my lord, 5 writ petition. In the other writ petition, 1 petition, my lord, only 1 petitioner, my lord, is in the my lord, in the post cadre of deputy director. The cadre of deputy director also, my lord, there were vacancies.
4 vacancies. Page 55.
My lord.
Yes.
And the petitioner in that case is the, my lord, in the serial number 1 in the redemption list.
But then,
He has already retired from service.
so at that moment, there is a, so vacancy. There is a vacancy, yes, that is for superintendent of fisheries. Yet to be filled up, application for the post of the, to promotion from PK doctor. Yes. And also, let me go through theirs as well. One more thing. Though that is true that vacancies are there at the zone of here after going to a record. But now we have amended the rules. Also. Now we have amended the rules, whether it will be considered or not.
Heard in part for further hearing next week. The according to the petitioners, in terms of the rules, the authority is to make at the beginning of each year, the concerned authority is required to make an assessment of the vacancies likely to arise during the course of the year in various cadres, and thereafter take steps for assessment and promotion of the eligible candidates. So far as the petitioners in WPC 421 is concerned, they considered themselves eligible for being promoted to the post of the DFDO, District Forest Development Fishery. So, insofar as the writ petitioner in the other writ petition given, what is the other writ petition? WPC
2653.
653, the petitioner therein was eligible for being promoted to the post of deputy director. fisheries. So counsel to the petitioner submits that the year-wise vacancies position for the posts of DFDO are enclosed in the communication dated 7th March 2024, showing 10 vacancies available. And insofar as the posts of deputy director, 6 posts are available. Stop. Notwithstanding that, in pursuance, in view of the mandate of the rules, is it 6 posts? Have I quoted the vacancies correctly, or is it?
My lord,
That I will
existing vacancies, was correctly quoted, my lord. The anticipated vacancies, they have been considered that.
Subsequent, the anticipated vacancies, and I would cite the reference of the letter. Continue. Those vacancies came to be filled up by way of DPC help, and the candidates who were considered were also promoted. Subsequently, by communication dated 29th of October 2024 in bracket NHS 7, the anticipated vacancies. These are anticipated.
My lord, existing vacancy, my lord.
Huh?
Immediately after my promotion order was made, these were fallen vacant, my lord. These were lying vacant.
The vacancy, another list of vacancy was circulated was communicated from the Director of Fisheries to the Additional Secretary, Department of Fisheries. In the same list, there were 4 posts of deputy directors shown to be vacant as on 23/10/2024, and 7 numbers of DFDO posts are shown to be vacant as on 23/10/2024. So the council petitioner submits that that the department proceeded to hold the DPC on 16 March 2024 for filling up of these vacancies. No, sorry. Where is the DPC?
That was held on, my lord.
Page number
9/4/2025, my lord.
Page number.
My lord,
11/4/2025.
Page number.
I have mentioned the paragraph 9, page 11.
Paragraph.
Paragraph 9, my lord.
The said DPC held its meeting on 9/4.
11/4.
11/4/2025. Where is the DPC minutes?
This is that. This is.
Huh?
This part is only members present.
This is what you given me 16/3/24.
This is the earlier one also. Earlier batch. This is the I have given.
You have given.
I have already given. I'm back.
The minutes on 9/4/2025. You said 11/4. It is 9.
It is signed. Lordship, it is signed 11/4.
Whereby instead of filling up these vacant posts, there was a recommendation for amendment of the rules. Stop pursuant thereto, the amendment of the rules took place. Stop all of the petitioners are not the same, the amendment of the rules. The advance is that the rights accrue to the petitioners sent to the next higher posts where not been considered, which amounted to violation. Besides the violation of the procedure prescribed under the rules, and the learned counsel to the petitioner therefore submits that presses into service the judgment of branch submit that the rights accrued petitioners ought to have been considered in the light of the specific and clear provisions of the stop. There are Mr. Sharma, learned standing counsel to the finance, 6 liberty of the court, the fishery department, 6 liberty of the court, whereas the judgments which are referred to and relied upon by the court is agreed to. This matter again next week. Counsel to the parties are permitted to submit list of books, list of judgments.
Can I
Next week they have it.
bind the judgments along synopsis of the? Can I bind the judgment along with the?
No, I don't need anything. You just give us the list along with the citations
Let
and
me
maybe
give
the
me also.
paragraphs and
Let
share
me-
it. Don't go to the extent of binding judgments and giving to us. We have everything.
Was it, can you mention, June, yeah, we need also, June,
Huh?
June 2nd, not it.
He should be worried about it.
Like-
Why are you worried?
He was also,
That will be listed in the first week of June. Or second week.
2nd June,
Second week of June.
2nd June.
2nd.
Second June. 9 June.
On that.
Plus,
Of that.
Time is too short
Hmm.
to complete our argument. That may be fixed.
What is your grievance?
Agreement is I am removed from service.
Why this 2016 matter is pending?
Yeah. You have not listed. Subsequently, we have to find mention. So last week of June.
No, let it come in July in the part 2 hearing list. You make a mention before the court. The matter, there is already an order passed on 15/11/2017 that the matter should be listed in the next available part 2 hearing list. So accordingly, registry will list this matter, the part 2 hearing list in the month of July. Mr. A. Sahat for the petitioner, Mr. Sharma.
B. Sharma.
B. Sharma for the state.
CGC.
CGC.
Offline.
This matter, my lords, I would like to file other number, freshly engaged.
Mr. D. Gogoi, learned counsel for the petitioner submits that he has been recently engaged in the matter. We like to complete his instructions and file necessary part. Please for
Okay.
4 weeks time. Or list accordingly after 4 weeks. Yeah.
Lordship, issue is other very limited lordship. I want only my salary for the period after my dismissal has been set aside by the appellate authority. That is the only, because by this time I have returned and I'm getting
Dismissal
pension,
set aside, salary not paid,
not paid.
right?
Because lordship will come to the appellate order, lordship.
Lordship, here some technical error has crept in, Lordship.
Lordship, the appellate, after the setting aside of the disciplinary proceedings, Lordship, that means the punishment, Lordship. He has been reinstated. Then there was, Lordship,
Page
the
20,
period.
Lordship will come to page 21, Lordship. After Lordship, paragraph 6, there is the subpara, the last line, Lordship. The appellant shall be deemed to be in service as ABC during this period.
Regarding pay and allowances, nothing has been mentioned.
What is that?
The last line, Lordship, the
Directed to
subpara.
revoke.
Disciplinary
authorities therein appellant shall be deemed to be in service.
Deemed to be in service. Then he issued the order, the SP issued the order, page 22.
But
the last line, he said that shall be deemed to be in service during this period. On the same day, then he issued another order, whether he could have done so.
Another order?
Page 23.
Stating?
Now he's saying that it will be treated as no work, no pay.
No work, no pay. This is their Lordship.
It's only 11.
That was not the order of the appellate authority.
Lordship. No. Only 11 months salary that I will get.
But appellate authority, Lordship, there is one thing is that the appellate authority that they have made party, Lordship, they are not the party here. They have. That's why we are not getting the proper information also. This has been conveyed to us, Lordship.
The appellate authority is the Deputy Inspector General.
Yes. Western Range. What they have said is Central Western Range, but this has not been done. And this is our letter. And
can you see page 21? It is DIG, Central Western Range.
Yes, not Central Western Range, Lordship. This has been bifurcated, Lordship. That's why.
It was Central Western Range.
Central Western Range. It is there. It does not fall under Central Western Range. Morigao district was bifurcated from this range to Central Range, presently headquarters at Dipu, by government notification dated 1/7/2022.
Does it make any difficult to get the records from there or instructions from there?
Lordship, without proper making the proper party, Lordship, or without any direction, we cannot seek this from the authorities, Lordship.
It's a very, very technical.
Technical, yes,
and
Lordship.
Very, very insensitive submission. You are represented, the Commissioner Secretary Home is there, Inspector General is there, Deputy Inspector General is there. If you want, we'll direct the Director General of the Police to be arranged. Then can be redirected to whichever authority.
We have written so many times, Lordship.
No. You have written.
Affidavit has been filed.
Affidavit filed by the respondent number 4.
Then?
He is below the rank of, that means this.
He is the
Lordship.
Superintendent.
Superintendent, Lordship. He is below that rank.
So records are available where? He's filed the affidavit, so it must be available to him. How is it possible that he'll file an affidavit without records?
Lordship, this is true, but regarding this particular instruction, Lordship.
What is the averment here in the affidavit regarding the order of the appellate authority?
Lordship, in page 28, paragraph 9, we have stated, Lordship.
They have admitted this, that there is no direction.
Yes. And that's why, Lordship, no work, no pay.
But on what authority? Unless.
This interpretation, Lordship, that there must be some authority, Lordship, maybe.
Lordship, first judgment, that produced next day, Lordship, that
Dipali,
Assam Rifle case, Lordship.
No, not Assam Rifle. Dipali, or something like that. That judgment is there, work no pay. You examine and come back next week, day after next, week after next. But all these matters should be in part 2 hearing. Why is it in part 1 hearing? Let it be listed in the part 2 hearing in the month of July.
Deeply obliged.
The Chakraborty for petition and Zen Bhattacharya for the response. Council for petitioner submits
Lordship,
very like-
there is issue is small, Lordship.
No, issue is small, but you don't have the judgment. You should have decided right now. But the judgment would be necessary. Dipali, you ask your colleague, Mr. D. Gogoi, he will recollect. The matter we had decided that. At least after 1 week. Or list in the part 2 hearing list, you make a mention whenever you find it. Yes.
Right, please resolution, my lord. My lord, last again was hard this matter, my lord. Matter relates to that, my lord. But the petitioner was supposed to disclose whether any case was pending at the time of my lord appointment, my lord. At the time of appointment, my lord. And my lord, here see stated in the affidavit that no case is pending. However, my lord, one affair was pending. Now, our ground before your lordship is that, my lord, while the affair was yet to be, charge sheet was yet to be submitted before the competent court, the affair was in the investigation stage, my lord. So,
Where
on
is
the-
your statement in the affidavit?
Yes, my lord.
Page number 36.
Right,
No criminal case.
no criminal case. My lord. Paragraph 4, my lord. So, my lord, the requirement was that, my lord, whether case was pending. Now, my lord, since the affair is at the stage of investigation and the charge sheet was filed, my lord, only on, my lord, 21/7/2023. My lord, already she was appointed on, my lord, 1/11/2022, my lord. After 1 year, the charge sheet was about 1 year, charge sheet was filed. And even in the charge sheet also, she has been discharged from the offense, my lord. And it's in some circumstances, my lord,
Then
that,
there was a proceeding.
there was a proceeding, my lord. And there in that proceeding, against the, my lord, order of dismissal, I also filed appeal, my lord. In the appeal, we have taken the grounds that during the proceeding also, my lord, that examination process was not.
What is the rules? What do the say?
My lord,
Or the notification saying that what you are required to disclose?
my lord, whether any case was pending.
Where does it say so?
In the affidavit itself, they take, my lord, they taken that affidavit. Lordship just pointed out page 36, and this is the affidavit they took. And the notification must be with the respondent, my lord. And now, so far the special circumstance under which she made the statement, my lord, that is to be considered, my lord, by the department that has not been. Because in her written statement in the inquiry, she stated, my lord, page 33, my lord, that on the advice of advocate, my lord, since the case was under investigation, page 33, my lord, she submitted the affidavit on the draft, on the basis of drafted by the advocate concerned. So therefore, my lord, in the humble submission before this honorable court is that, my lord, there is no, my lord, ill intention on the part of the petitioner to suppress any case, and that too, the affair was yet to take a shape.
Where is the form? Where is the form? Where you have to?
Office paper time is there, my lord.
Where is it?
Yes, yes. The office paper time, there is a paper of, my lord, some clauses as there. If it is a license, my lord. She have admitted it.
You're not available on the record.
Yes, record available. Is a
I
record.
mean, the case record.
Not there.
Not that day, my lord. That was not a. Still number 4, I think.
No, so where is the, where, under what rule, what form is the notarized affidavit required? In terms of this office memorandum?
Yes.
It only says that if there is any information which is contrary.
Contrary, my lord, because these clauses, but whether criminal case is pending or not.
So, no, where does it say so? It doesn't say so in this office memorandum.
This was the office memorandum.
No, office memorandum says,
If any, it is found contrary to the
if it
declaration.
is found contrary.
Yeah, to declaration.
What is contrary?
Contrary, my lord, she said, my lord, no criminal cases pending. We found that there is a charge sheet is there, criminal cases pending, and the allegation is, my lord, serious. She is involved in the unlawful activities. So and
No
so.
pending criminal case.
Criminal
What is
case.
the meaning of criminal case?
Criminal case that the FIR has been lodged. That is what investigation done.
Does it become a criminal case or after filing of charge sheet?
Yes. No, after filing of charge sheet, my lord, that is defined, my lord. When she was appointed, at
There
that
was an
moment,
FIR filed.
FIR file and case was progress was registered. Case was registered. Charge sheet later on filed, of course. But clause 8 say if it is found contrary to the
Is there
declaration.
any definition of what is a criminal case here?
Yes.
In the rules?
My lord, rules para
On this memorandum, nothing.
nothing, my lord. And so far, I think, my lord, on this point, judgment is that, my lord, special circumstances under which he has made, and that could be considered. And moreover, my lord, these judgments also, this says, my lord, that in such cases, that too, when there is the case, criminal case lead to, my lord,
No, we are not on whether it leads to
Yes,
conviction
research.
or acquittal.
yes.
You made a statement that there is no pending criminal
Correct,
case.
correct.
What is the meaning of criminal case?
Criminal case, my lord, from the judgment, what I gathered, my lord, that on that
Show us
FIR,
the judgment.
right. FIR, my lord, yes. FIR, my lord, that put the, my lord, the motion of a criminal, my lord, activity.
Which one?
Now, on investigation, Lord,
Which
that the
matter?
list of, yes.
Which case?
First, I was, my lord, relying upon that in a service jurisprudence that KV Janakiraman, it is also for, my lord, silkover. However, there is a, my lord, clear quotation, para 8, my lord. Para 8 is the questions. Para 8, what is the date? Number 1, my lord, what is the date from which it can be said that disciplinary criminal proceedings are pending against employee? For the courts, when the employee is guilty in the proceeding, if the guilt's punishment other than that of dismissal. So for number 1 question is that answer is at page para 16, my lord. On the first question, namely, as to when for the purpose of silkover procedures, a disciplinary criminal proceeding can be said to have commenced. Full bench of the tribunal has held that it is only when a search memo in a disciplinary proceeding or a a search sheet in a criminal prosecution is issued to the employee that it can be said that the departmental proceeding, criminal prosecution is initiated against the employee. So far the service, this is also administrative service matter. Now, so far here in this present case, my lord, charge sheet, also kindly have a look at the list of that. Para 6, charge sheet was laid on 21/7/2023. After I give the
This is the
information.
only judgment you are relying.
Yes, my lord,
No other.
next, my lord, yes. Next, my airport authority, my lord. There, my lord, para 17, 19, and 20 from this honorable High Court. My lord, here also categorically stated. I may directly read, my lord, para 20, my lord.
Para 17.
Yes, para 17, 19, and 20, my lord. There are so detailed said, my lord, what is criminal procedure, what is the criminal investigation, my lord. And then This is from a Bombay High Court judgment, my lord. No doubt that the para 17, my lord. So may set in motion by giving information to police for cognized offense, but unless proceedings are instituted in the court of law, it is not correct to say the criminal proceedings have been instituted. Now, my lord, from the analysis para 20, what the Honorable Court held, my lord, we are in respectfully agreement with the decisions of Allahabad High Court, Bombay High Court, Nagpur High Court, Rangoon High Court, even if the decision of the Calcutta High Court and Madras High Court are also same applicable, that also will not change the color of the present. As a matter of fact, there was no need for us to decide this question, but it has been decided by us because it was ours and argued vehemently by the Learned Counsel for Appellant. We hold that a criminal proceeding comes into existence only when the matter comes for the court and not earlier to it. For example, for the purpose of staying in department, in the case of staying of departmental proceeding, that was held, my lord. So, my lord, in this case, Sarsit submitted later on that ended in, my lord, discharge. Now, my lord, so far non-disclosure is concerned, my lord, this is
What are the other judgments?
yes, Robindra Kumar, my lord, versus State of UP, 2024 5 versus 264. There, my lord, paragraph 1 itself, my lord, that question, it is a facts question come again. It has been started like this, my lord. It is a hard and fast cut and dried rule that in all circumstances, non-disclosure of a criminal case in which the candidate acquitted in verification form is fatal for the candidate's employment. We think not, and it ought not to be so too. Now, para 22, my lord, I mark the paragraphs, lordship. That well-known outsourcing case was referred. What is about and how to proceed, my lord?
Photocopy is not.
I will give a fresh one.
Words are not there.
I have sorry. So one beautiful line on the para 24, sub-para there, my lord, 12. Para 24, 12. It is true that in the application from the respondent did not mention that he was involved in a criminal case under section. Probably he did not mention this out of fear that if he did so, he would automatically be disqualified. At any event, it was not such a serious offense like murder, Gauhati rape, and hence a more lenient view should be taken in such matter.
Paragraph?
Paragraph, my lord, 22. There, my lord, italics, in italics, also will find it is quoted from Maurice Crown's office, that judgment, my lord, 1972.
Para 22 of which judgment?
Para 24, my lord, that
24.
yes, Robindra Kumar judgment, lordship. Para 22,
Avatar Singh.
after Singh started with, then, my lord, sub-para 12. It is started like this, my lord. It is true that in the application from the respondent did not mention that he was involved in a criminal case under section so. Probably he did not mention this out of fear that he did so would automatically be disqualified. At any event, it is not such a serious offense like murder.
Yes, sir.
And my lord,
Sukiya like to
My lord, I like,
respond to the judgment which are
yes,
placed?
my lord, I like to, my lord, place before your lordship, one judgment after seeing.
Yes.
After seeing, my lordship, kindly see paragraph 38, start from 38.
38
38.
here after seeing.
Oh, yes, please, my lord. We have noticed various decisions and tried to explain and reconcile them as far as possible. In view of the approach discussion, we summarize our conclusion.
Yes.
Number one, information given to the employer by a candidate is to conviction, acquittal, arrest, and pendency of a criminal case, whether before or after entering into service, must be true, and there should be no suppression or false mention in required information. While passing order of the termination of service and cancellation of candidature for giving false information, the employer may take notice of special circumstances of the case, if any, while giving such information. 3.8. Employer shall take into consideration the government orders, instructions, rules applicable to the employee at the time of taking the decision. So there is a ballot notification. In case there is a suppression or false information of involvement in a criminal case where conviction or acquittal had already been recorded before filing of the application, verification form, such fact later comes to the knowledge of the employer, any of the following recourse appropriate to the case may be adopted. In a case, travel in the nature of either which the conviction has been recorded, such as shouting slogans at young age or for a petty offense which is disclosed would not have rendered an induction incumbent unfit for a post of question. The employer may, in its discretion, ignore such suppression of the fact and false information by the concluding the lapse. Where conviction has been recorded in case it is not trivial in the nature, employer may cancel candidacy or terminate services of the employee. If acquittal has already been recorded in a case involving moral turpitude or offense of heinous or serious nature, on technical ground, it is not a case of clean acquittal and benefit or reasonable doubt has been given. The employer may consider all the relevant facts available as
No,
to
the question now here is, what is a criminal case?
now, yes.
My lord,
There is a division bench of the judgment of the
Right.
this court saying that it comes into existence only when the
Charge
matter
sheet.
comes before the court.
Yes, after filing the FIR, definitely it has gone to the
Now
court.
the question is, what is that criminal case that you are looking for? Is it a case as understood with the matter pending before the court, or is it just
Information.
an allegation? Even an FIR is a criminal case. I mean, how do you define it?
That is not actually, I have not gone in, found in the records, my lord, in which that case was forwarded to the court. Now, FIR lodged in the police station, okay. Thereafter, they have, my lord, inquiry the matter, and when it is sent to the, after arrest, they have sent to the court. If it is pending in the court, it is a criminal case pending. So before filing of his affidavit.
But in your proceedings, there is no finding that it was pending in the court.
Yes, there is there, my lord. So cause notice is there. He was asked to show cause as to why this one, my lord. First show cause is page 30.
Where is the departmental inquiry report?
Inquiry report there is there, my lord. Gist is there, but I can say
I
there is
have
a-
taken that ground also, my lord. Inquiry report in the inquiry has not been served to us.
Inquiry report was very clear.
it was served, I think, my lord. I have to give the report. In serial number 5, my lord, page 4 records. Borobari Outpost Dipankar Bora Dibrugarh submitted FIR to the OC Dibrugarh PS on 6/8/2019. In the FIR, Kobita Kaman along with 3 others found to be involved in the alpha whole extortion of money, etc. And detailed report submitted by the OC Dibrugarh PS case number on Dibrugarh on 28th of February 2024, stating that 4 persons arrested, including Kavita Kaman, who were involved, extortion and associated militant organization. That is, my lord, OC Dibrugarh PS submitted to the SP Dibrugarh on 20th of February 2024.
But this is in terms of investigation.
Yes, investigation.
Was
The
the charge sheet
commander,
filed?
page 8, Commando Battalion Dubai regarding initiation of DP against Kubita Kaman as the fraudulently obtained the job, making false statement in the affidavit that no criminal cases pending against her. Ulokesh Rava Suvanso is appointed employee officer and presenting officer. And first of course notice was Suvanso. Page.
Where is the inquiry report?
Yes. Inquiry report submitted by on page 57, 59. Yes, here is not page 59 and 57 the records. Inquiry report submitted by the inquiry officer. And second so cause notice was on 19/9/2024.
So what is the conclusion of the inquiry?
Inquiry conclusion one. Conclusion, my lord, after taking the statement of witnesses under the above and circumstances irrespective of the criminal case pending against her, the charges of gross indiscipline and gross misconduct leveled against the delinquent so Kavita Kaman is proved beyond reasonable doubt, submitted to the disciplinary authority, permanent source. That is the my lord, findings. So Kaman was also examined and recorded her statement with the DP number drawn against her, and she stated that during she joining in the Gulaghar district, she submitted an affidavit on 1/11/2022 of Gulaghar Notary, where he mentioned that the clause 4 that no any criminal case is pending against her, and in clause 6 stated that she is not member or associated with anybody or association declared unlawful. Hereby, she violated the subsequent clause 6, 7, 9 of this notification. She was arrested by the Dibrugarh police and so on 7/8/2019 before interview and forwarded to the honorable court. But she was unknown about the present status of the case, which is totally false statement. The delinquent also submitted report on 28 August 2024 that she has no defense witness. Yes, but delinquent also submitted report. He was given report. And he has no defense witness to produce the DP drawn against her. That is the blood inquiry.
When was the charge sheet filed?
Charge sheet filed, my lord, charge sheet
Is there any finding?
sheet.
The second so cause, my lord, para 37, they have mentioned that charge sheet was filed, charge sheet number 270/2023 on 21/7/2023, my lord. Para page 37, my lord, third paragraph, my lord, third line.
21/7.
Yes, lord.
And when did you file the affidavit?
My lord,
22.
yes, 1/11/22, my lord. Yes, my lord. That time, my lord, case was not before the competent court, my lord. The case was under investigation also. That aspect they have not considered, my lord.
Charge sheet is concerned when the departmental proceeding is going on, my lord, so the promotion is concerned employee, whether charge sheet is filed or not. If the charge sheet is not filed, then her case will be considered.
On what basis are you saying it? Because we want to know how do you project a criminal case? What is the meaning of criminal
That
case?
is, my lord, I will have to go through it, my lord. I will have to see what is the actually.
There is a judgment of this court saying that it is only when it comes before the division bench. It's a judgment.
But his charge sheet submitted on 21/7/2020.
So affidavit is before that,
Yes.
but it was during the pendency of the criminal FIR.
FIR.
Right. Further hearing.
Ninth.
Month.
Ninth
Okay.
of-
9th of June. Okay.
Please give the list of books and both
Yes.
parties.
Month.
Twenty-two left over. Last, this is the last item. Take it up. Interim. So let it be in July.
The transfer matter also.
Trans-
Can it be the next week?
Not next.